So with that said, I want to now turn it over to our first instructor for today. He is one of our attorneys practicing, like I said earlier, only community association law out of our Palm Beach Gardens office. This is Ben Heidloff. Ben, how are you, sir?
I'm doing well. Thank you, Jeff. Thank you, ACAM, for hosting this. Hello, everybody. I hope you're doing well. It's interesting for all of you prospective board members or board members maybe that have just been elected. I never am quite sure what to say, whether it's congratulations or condolences, but only time will tell. But we appreciate that you're here, that you are getting your certification with us. As Jeff mentioned, this is a 4-hour course. We will try blaze through it in less time than that, but still share with you the pertinent information. Real quick about myself. My background was human resources for a number of years. And then in 2017, boy, did I make a poor life decision and go to law school. And I'll tell you what, and yes, I'm saying that facetiously. Um, Law school changes you. You forever think differently, and you just approach things differently, and you don't speak the way that you normally or previously spoke. So forgive me up front about that. I have been programmed for 3 years in law school, but nonetheless, I'm here. We'll share. We'll have a fun time. Try to do it with a sense of humor. Having said that, I enjoy community association law. When I first graduated law school, I was actually in the world of family law. I was an adoptive parent and went through a number of legal issues, and that's kind of what prompted my interest in going to law school. So about 4 years, I practiced family law, dealt with spouses in difficult situations and people that didn't like themselves. And then I transferred into the world of association law, where the board members always cooperate and love each other. So there was absolutely no crossover whatsoever.
Always, all the time, and everything that comes out of Tallahassee makes sense 100% of the time too, right? Right, everybody? Perfect sense.
So again, I appreciate being here. And again, because this course is 4 hours, you will see me stay hydrated. I do have a red Solo cup. Please do not judge me. It is only water inside of this red Solo cup. However, what is inside your red Solo cup stays with you.
And I'll mention one last time, folks, who might be just joining us. There's no signing in. The link you use to join is signing in. Good to go. That's why we say don't share your links with anybody. Ben, back to you, sir.
Thank you. And before we jump into topic one, I wanted to mention there is House Bill 913 kind of hanging out in the ether. And it is waiting for the governor's signature. Now, that particular legislation, it is not law yet. It could become law really anytime. But it basically addresses and will change certain provisions within Chapter 468, which deals with community association management, Chapter 553, which deals with milestone inspections, as well as the Condominium Act 718. So I just want everybody to be rest assured that what you are going to be learning today is still applicable, but I did want to at least forewarn you that there are some potential changes on the horizon, and we'll see if this becomes law sooner or later. So topic one, I'm going to be taking you all through the milestone inspection requirements and the structural integrity reserve studies, also known as SIRS. And for those legal eagles out there, you'll see these statutes. So statute 553.899 is really dealing with building construction standards. And then, of course, Chapter 718 is our Condominium Act. So, milestone inspection requirements. First off, some of you may not know what is a milestone inspection. So essentially, a milestone inspection, it is a structural inspection of the building, and it includes an inspection of load-bearing elements and primary structural members, as well as structural systems. Now, for our purposes, a primary structural member is a structural element that's designed to provide support and stability for the vertical or lateral loads of the overall structure. And then we've got a definition of primary structural systems, which is basically the assemblies that make up the primary structural members. Now, these milestone inspections are performed. Oh my goodness, shame on me for using my mouse. I'm going to go hop here to my arrow keys. So the milestone inspection is actually performed by an architect or engineer that's properly licensed in the state of Florida, or it actually could be performed by a team of professionals with a architect or engineer that acts as the registered design professional and who is ultimately responsible for the work and the reports and making sure everything is signed and sealed. And literally the purpose of the milestone inspection is really to confirm the life safety and the adequacy of the building structural components, and to the extent possible, determining the building's general structural condition as it applies to safety, and then includes a determination of the necessary maintenance and repair or replacement provisions of any structural component of the building. Now, having an idea of what the milestone inspection is, what the milestone inspection is not, it's not to determine if the condition of the existing building is in compliance with the Florida Building Code or the Fire Safety Code. The question always comes up, hey, do we need a milestone inspection? Well, like any good legal answer, it depends. So an owner or owners of a building that is 3 stories or more in height, and that's determined by the Florida Building Code, and that is also subject in whole or in part to the residential condominium form of ownership, meaning 718 is applicable, must comply with the milestone inspection requirements. Now, there are certain exclusions as well. So if it's purely a commercial building or purely a commercial condominium, there's an exclusion there. And there's also an exclusion for single family, 2-family, 3-family, or 4-family dwellings that have 3 or fewer habitable stories. So they're really taking out the single family homes and townhomes by doing that. For some of you that might be in a mixed use, such as a hotel condo, and we certainly represent some of those type of associations, the inspection report must be arranged by the Residential Condominium Association and any owner of any portion of the building which is not subject to the condominium form of ownership. So essentially that means both the association as well as the owner of the non-association, whatever portion of the building that may be, is subject to this milestone inspection. So each of the owners are responsible for ensuring compliance with the requirements for the milestone inspection. And then probably more pertinent for you all is that the condominium association is responsible for all the costs that are associated with the milestone inspection and that are attributable to the portions of the building which the association is responsible to maintain and repair, subject to the association's governing documents, meaning the association's declaration, the articles of incorporation, the bylaws, and the rules and regulations. And then when do we need a milestone inspection? Well, the initial milestone inspection must be performed by December 31st of the year in which the building reaches 30 years of age. Now, in the next couple slides, we're going to be going through a number of dates and times. Don't worry, you don't have to take copious notes. You're going to get a copy of this presentation, but it's just good to know and be exposed to this information. So the age of the building basically is determined on the date that the certificate of occupancy for that particular building was issued. Now, if the certificate of occupancy is not available, then the date of the issuance of the building certificate of occupancy is the date that's evidenced in any record of the local building official. And that could be either with the particular municipality or with the county. Now, if the building reached 30 years of age between July 1st of 2022, the initial milestone inspection must be performed before December 31st, 2024. And of course, that date has already transpired. Now, if the building reaches 30 years of age after July 1st of 2022, but before December 31st of 2024, then the building's initial milestone inspection must be performed before December 31st of 2025. So we all have some time there. And then subsequent to that initial milestone inspection, another milestone inspection must be performed every 10 years after the previous milestone inspection. And then the local enforcement agency. And some of you might be asking, hey, Ben, what's the local enforcement agency? Well, really, the local enforcement agency refers to the local building department or the county's building department. Here in Palm Beach County, it could be the local municipality, such as West Palm Beach, or it could be Palm Beach County itself. So the local enforcement agency itself can require that the initial milestone inspection be performed by December 31st of the year in which the building reaches 25 years of age, and that's opposed to and instead of the building reaching 30 years of age. And for example, Palm Beach County is one of the counties that uses that 25 years of age milestone. And it's based on local circumstances, and it's including environmental conditions such as the building's proximity to saltwater. Now, interestingly enough, this statute 379.101 is actually a fish and wildlife conservation statute. So it's very, very interesting to note that even though we're really discussing things going on that have to do with 718, the Condominium Act, there are a lot of other laws and regulations that come into play that are applicable. Moving down, the local enforcement agency may, and we capitalize that word may, and I'll just share with you all, there has been thousands upon thousands upon thousands of dollars of litigation over what specific words mean. Specific words such as may, shall, must, will, and whether or not those particular terms are permissive or if they're mandatory. So in this case, the may we capitalize because it's permissive. So the local enforcement agency may extend the due date for the initial milestone inspection upon a showing of good cause that the inspection cannot be timely completed if the owners of the building have entered into a contract with an architect or engineer to perform the milestone inspection, and the inspection cannot reasonably completed before the deadline or other circumstance to justify an extension. And as you all are probably aware, we have a lot more associations than we do have licensed architects and engineers. So sometimes there is a backup, right? Associations have to wait before someone comes available to be able to do the initial inspection. So for milestone inspections that were prepared prior to July 1st of 2022, the local enforcement agency may accept an inspection report that's been prepared by the engineer or architect for a structural integrity and condition inspection of a building if the inspection and report substantially comply with the milestone inspection requirements. And that will be up to the determination of that local enforcement agency. However, regardless of when the inspection was completed, the association still must comply with the unit owner notice requirements of that section 553.899. And what this really means is that the association has to provide a copy of the inspection report to the members. And you'll see some more information about that coming up here shortly in a future slide. So in the event the previous inspection report is accepted by the local enforcement agency, then That previous inspection is deemed to be a milestone inspection for the purposes of satisfying the Condominium Act. And then the deadline for the building's next 10-year milestone is based on the date of the accepted previous inspection. So if your association has been notified that you need a milestone inspection, what's next? So upon determining that a building must have a milestone inspection, the local enforcement agency, look at this word, must, it's not permissive. So that local enforcement agency must provide written notice of such required inspection to the association and also to any owner of any portion of the building which is not subject to the condominium form of ownership. It's got to be sent by certified mail, return receipt requested. And that other portion that you see there is referring to maybe a commercial portion of the condominium, or going back to our condo hotel previous example. Thereafter, the association must then notify the unit owners of the required milestone inspection. The association has 14 days in which to do that after receipt of the written notice from the local government, and provide the date that the milestone inspection must be completed. And then the milestone inspection itself consists of two phases. Phase one is a visual examination, and depending on the outcome of that visual examination, phase two may or may not be required. And we'll talk about that here just momentarily. So the phase one is where the architect or engineer performs a visual examination of both the habitable and non-habitable areas of the building, and is looking at all of the major structural components of the building, and is really providing an assessment as to the structural conditions of the building. You know, Lord forbid, we're probably all familiar with what happened down with the collapse in Surfside and the Champlain Towers. Horrible, horrific. We never want that to happen. So that's why with the legislation passing the initial SB4D bill is really where these milestone inspections came to the forefront. The architect or engineer who performs a phase one milestone must prepare and submit an inspection report. And that inspection report must be completed within 180 days after the owners of the building receive the written notice that a milestone inspection is required. And the completion of phase one really means that the architect or engineer who performed the phase one inspection submitted the inspection report either by email, US mail, or some other commercial delivery service, FedEx, UPS, etc., to the local enforcement agency. And then if the architect or engineer finds no signs of what we call substantial structural deterioration to any of the building components that were under visual examination, phase two is not required. And here in just a moment, we're going to find out actually what that term substantial structural deterioration means. For our purposes, substantial structural deterioration, and I'll refer to it as SSD, means that there is substantial structural distress or some type of substantial structural weakness that negatively affects the building's structural condition and integrity. Now, there are certain things that may not constitute substructural structural deterioration. And so unless the engineer or architect performing the inspection determines that the surface imperfections are a sign of that SSD, substantial structural deterioration does not include surface imperfections. So things like cracks, distortion, sagging, certain deflections, misalignments. Here's a fun one, signs of leakage. That cannot be good, but may not necessarily lead to the substantial structural deterioration, as well as peeling of finishes. So for phase two, If the architect or engineer does find any substantial structural deterioration, that phase two may involve either destructive or non-destructive testing. And so what they're really talking about here is destructive testing, right? There may have to be certain portions of the buildings or certain spots where we strip away layers of the onion. And this is often common. If any of you have ever gone through a concrete restoration project, you know that as layers of the onion get peeled back, it's not uncommon to have additional damage that is apparent that never would have been seen if not for actually removing the outer layers. So this is where that destructive testing comes in. Now, as far as the inspection itself, can be as extensive or as limited as necessary to fully assess the structural distress. And that's basically done in order to confirm that the building is structurally sound, safe for its intended use, and really designed to recommend a program for assessing and repairing those damaged portions of the building. Now, as similar with phase one, you're going to see a lot of common timelines here. If a phase two is required, then within 180 days after submitting the phase one report, the architect or engineer who performs the phase two inspection must, here we go, so that's mandatory, must submit a phase two progress report to that local enforcement agency with a timely completion of the phase two inspection. And then the inspector who actually completes the phase two must also prepare and submit an inspection report. Now, there are certain inspection report requirements. So upon completion of phase one and phase two inspection, the architect or engineer who actually performs the inspection must submit a sealed copy of the inspection report along with a separate summary of the material findings and recommendations in the inspection report. And those documents have to be given to not only the Condominium Association, they've got to be given to any other owner of any portion of the building which is not subject to the condominium form of ownership. So again, we're going back to that maybe commercial condominium example or the hotel condo example. And then also copies must be given to the building official of the local government, which has jurisdiction. Now, as far as certain requirements of the inspection itself, the inspection report must at minimum meet some of the criteria. So it's got to bear the seal and signature or the electronic signature of the engineer or the architect who actually performed the inspection. It's got to indicate the manner and type of inspection that forms the basis for the report itself. It needs to identify any of that substantial structural deterioration. And this is interesting, within a reasonable professional probability based on the scope of inspection, describe the extent of such deterioration and identify any recommended repairs for such deterioration. So there's a little bit of guesswork here too. The inspection must state whether unsafe or dangerous conditions, as those terms are specifically defined in the Florida Building Code, were observed. The inspection report has to recommend any remedial or preventive repair for any items that are damaged, but that may not rise to the level of substantial structural deterioration. And then the report's got to identify and describe any items that require further inspection. Now, along with the architect and engineer having certain requirements, the association has certain requirements as well. Within 45 days after receiving the applicable inspection report, the association must, and again, not mandatory, must, mandatory, distribute a copy of the inspector prepared summary of the inspection report to each unit owner, regardless of the findings or the recommendation in the report. And that summary's got to be sent by United States mail or personal delivery to the owner's mailing address, or for those individuals or members who have opted in or consented to receive email notices, it can be sent by electronic means. Additionally, a copy of the summary has to be posted on the property in a conspicuous place on the property. So if your association has an area where maybe it posts the board meeting notices or the agendas, might be the perfect place to put this as well. And then the association is required to publish the full report and the summary on the association's website. Now, if the association is required to have a website, and as of January 1st, 2026, if your association has more than 25 units, you will be required to maintain a website. Now, local government can enforce the repairs. So, for example, Board of County Commissioners or the municipal governing body could adopt an ordinance requiring that the repairs for that substantial structural deterioration be scheduled or commenced within a specified time frame after the local enforcement agency receives a phase 2 inspection report. But however, the repairs must be commenced no later than 365 days after receiving the report. So there's a year grace period there. If the owner of the building fails to submit proof that repairs have been scheduled or that repairs have commenced for the substantial structural deterioration that's been identified in the phase 2 report within the required time frame, then the local government must review and determine if the building is unsafe for human occupancy. So nobody wants a red tag on their building. Nobody wants to be forced to move. So it's definitely important to abide by these timelines. Now, failure to obtain the milestone inspection. Now, here's one that's very important for all of you. And this is not meant to scare you, but we're just sharing the information. If the officers or directors of an association willfully and knowingly fail to have a milestone inspection performed, such failure is a breach of their fiduciary duty. And this is one area, there actually are a few areas, but this is one area where officers and directors can be held individually liable. Okay, so if there's a breach of fiduciary duty, normally things like the directors and officers insurance, there's indemnification provisions more often than not in the association's governing documents. But a breach of fiduciary duty, this is one area where officers and directors can be held individually liable. Again, not meant to scare you, but just sharing that information because it's an important point. The local enforcement agency itself may prescribe timelines and penalties with respect to compliance with the milestone inspection requirements, and those are most often addressed through things like fines. Now, Florida Building Commission requirements. So by December 31st of 2024, and of course that date has passed, the Florida Building Commission must adopt rules establishing a building safety program for the implementation of the milestone inspections, and that is contained within the Florida Building Code. And then the building inspection program must include at minimum inspection criteria, testing protocols, standardized inspection and reporting forms that are adaptable to use in electronic format, and then record maintenance requirements for the local authority. And just to let you all know, the Florida Building Commission has adopted such standards, so that did happen. So now we're getting into structural integrity reserve studies and mandatory reserves. And the question comes up, what is a structural integrity reserve study? So essentially, a structural integrity reserve study, we'll lovingly call it the SIRS. It's a study of reserve funds that are required for future major repairs and replacement of things like and are related to the structural integrity and safety of the building. Now, these particular things can be found in Florida statute 718.112, but it's things like the roof, the structure, including load-bearing walls and other primary structural members. I know we've heard that term before, and primary structural systems. We've also heard that term before, as those terms are specifically defined in section 627.706 of Florida statute. It also includes fireproofing and fire protection systems, plumbing systems, electrical systems, waterproofing and exterior painting, windows and exterior doors that are maintained by the association. And then interestingly, here at the end, there's kind of a catch-all provision here. And it says any other item that has a deferred maintenance expense or replacement cost that exceeds $10,000 and the failure to replace or maintain such item negatively affects the items that are listed above. So that could potentially be pretty broad, and as determined by the visual inspection portion of the structural integrity reserve study. So it may not simply include those listed items, it could certainly affect other items as well. And then, does our association need a structural integrity reserve study? And again, like any good legal answer, it depends. So if you're in a residential condominium, you must have a structural integrity reserve study completed at least every 10 years. Now that sounds like an awfully similar timeline to our milestone inspection, doesn't it? So if you're all starting to pick up on certain timelines and dates, fantastic. So at least every 10 years after the condominium's creation for each building on the condo property that is 3 stories or higher in height, and again, that's determined by the Florida Building Code. And here there's also certain exclusions. So we're excluding buildings that are less than 3 stories in height. We're excluding single family, 2 family, or 3 family dwellings that have 3 or fewer habitable stories. And any portion or component of a building that has not been submitted to the condominium form of ownership. And again, this harkens back to our hotel condo or commercial form of condominium. Any portion or component of a building that is maintained by a party other than the association. And essentially, this means that those things are maintained by the unit owner, himself or herself. And then commercial condominiums are also excluded. Now, CEUs requirements. So as similar to the milestone, a structural integrity reserve study is based on a visual inspection of the condominium property. And so the study must at minimum identify each item of the condominium property that's being actually visually inspected. And it must state the estimated remaining useful life and the estimated replacement cost or deferred maintenance expense of each item of the condominium property that's being visually inspected. And it's really used to provide a reserve funding schedule that includes an annual reserve amount that achieves the estimated replacement cost or the deferred maintenance expense of each item that's being visually inspected by the end of the estimated remaining useful life of the item. And so here's another interesting kind of factoid. Fully funded, I'm sure you've heard that term before, fully funded reserves. As far as Florida is concerned, fully funded means something along the lines of the following. For example, let's say we have an AC component, cooling tower or otherwise, and the useful life of that item is 10 years. There's 10 years of remaining useful life, and that particular item costs, $100,000. So it doesn't mean that the association has to have in reserves $100,000 as of today's date. It really means that over the course of 10 years, on an annual basis, the association must set aside $10,000 per year. So by the time that 10 years is up, it is fully funded to basically replace that particular component. So although these things are expensive, and I'm sure you may have been subject to special assessments or otherwise for certain things, I just wanted to put that out there that just because you get this Sears study back doesn't mean that you instantly or instantaneously have to have the money to fund everything.
Then just going to do a quick interruption here.
Yes.
Some of you are asking why aren't my questions being answered? I am only answering questions that don't require having the ESQ after my name. So keep that in mind, folks. I'm only answering technical questions or generic questions about the material. I cannot answer any kind of legal interpretation stuff, even if I know the answer. So that's why. And then at the end of each instructor's presentation, they'll cover a couple of questions. The important thing is getting through all of this material in the allotted time. We want to get you certified. We'll get to a few questions, definitely not all, but we're going to try. And do not make any of them association specific. We don't have your documents in front of us. Keep questions on the material. But again, just want to put it out there. We're not going to be able to get to all of them. We have a lot of material in a confined period of time. And if you can't hear Ben, I could hear him fine. Turn up your volume. I don't have anybody else having audio or volume issues. I have, so it might be a setting on your end, folks. Ben, back to you, sir.
Thanks, Jeff. Appreciate that. And I'm moving on. Who can perform the CEUs? So the structural integrity of reserve study may be performed by any person qualified to perform such study. Hmm. Not necessarily helpful, is it? However, the visual inspection portion of the Sears study uh, must be performed or verified by an engineer or a licensed architect. So very familiar to what we had for our milestone inspection, we have for our CEUs. However, we have one additional bullet point down here, which reflects that the CEUs can also be performed by a person that's certified as a reserve specialist or a professional reserved analyst by the Community Association Institute, otherwise known as CAI, or the Association of Professional Reserve Analysts. So there is a little bit of broadening here on the CEUs side of who can actually perform the visual inspection as compared to the milestone inspection. So much as we did with the milestone, we also have deadlines that the association must meet to complete the CEUs. So associations existing on or before July 1st, 2022, and if the date sounds familiar, it should, which are unit owner controlled, meaning these are not developer controlled, must have a structural integrity reserve study completed by December 31st, 2024. For each building on the condominium property that is 3 stories or higher in height. If an association is required to complete a milestone inspection on or before December 31st, 2026, that association may complete the structural integrity reserve study simultaneously with the milestone inspection. But however, in no event may the structural integrity reserve study be completed after December 31st of 2026. And then if the milestone inspection is completed for a similar local requirement, was performed within the past 5 years, and meets the structural integrity reserve study requirements, that particular inspection may be used in place of the visual inspection portion of the structural integrity reserve study. So kind of similar to the milestone, there are other ways around it if that report meets the requirements. So we have a CEUs. Now what? Well, within 45 days after receiving the structural integrity reserve study, the association must, again, this is mandatory, distribute a copy of the study to each unit owner or deliver to each unit owner a notice that the completed study is available for inspection and copying upon the written request. And then the copy of the study or notice must be sent either by U.S. mail, personal delivery to the address provided by the owner. that fulfills the association's notice requirements, or it can be sent also by electronic transmission, i.e. email, to those owners who consented to receiving notice by electronic transmission, meaning, in other words, those people that actually opted in to receive electronic communications from the association. Now, we get down here. To any of you that remember the Brady Bunch, it was always about Marcia, Marcia, Marcia. Well, in this case, it's about to be all about the division, the division, the division. And when we talk about the division, we're actually referring to the Florida Division of Condominiums, Timeshares, and Mobile Homes. And so the association must provide the division with a statement indicating that the study was completed and that the association provided or made available such study to each unit owner in accordance with the above requirements. Now, the statement must be provided to the division in the manner established by the division using a form posted on the division's website. Boy, is that a mouthful. But if you have ever visited the division's website, literally on the home page, there is a link, and it's called literally CEUs reporting. And if you click on that link, it will open a page, and that page literally contains a fill in the blank form that you can do right on the division's website. So nothing scary or concerning about it. It's really kind of paint by the numbers. And the association is doing. I know certain property managers will do it on behalf of the association, but in any event, it is up and available on the division's website. Now, structural integrity reserve studies must be maintained for at least 15 years after the study is completed. Now, if any of you are familiar with the official records requirements that are laid out in section 718.111 of the Florida statutes, most of the association's official records are required to be maintained for at least 7 years, and there are certain exceptions. However, this is one of them, so that CEUs study must be maintained for a longer time, at least 15 years. And again, for those associations which must have a website, the structural integrity reserve studies must be posted on the association's website, or as we say here, they can use, being they, the association, a downloadable app. And again, what happens if we have a failure for an association to obtain the CEUs? So again, if the officers or directors of an association willfully and knowingly fail to complete a structural integrity reserve study, that failure is a breach of the fiduciary duty. And again, as mentioned before, this is one area where officers and directors can be held individually liable. So we don't want you to get in trouble for that. So we always suggest that you do what you can to both effectuate the milestone and the CEUs. I'm going to touch a little bit on the CEUs reserves. So in the event the association is required to obtain a structural integrity reserve study, those reserves must be maintained for the structural integrity reserve study items for which the association is responsible pursuant to the declaration. So those items that I mentioned before, the roof, the support structures, the fire suppression, et cetera, et cetera. The reserve amount for such items must be based on the findings and recommendations of the association's most recent structural integrity reserve study. And then the association may adjust replacement reserve assessments annually to take into account the inflation adjustments and any changes in estimates or extensions of the useful life of a reserve item that is caused by the deferred maintenance. And so this is really why we suggest that the association really engage a reserve specialist for these type of things, because you really need to know your numbers and you need to know how those numbers are allocated. Now, there are some reserves exemptions. And so If there's items where an estimate of the useful life is not really easily or readily ascertainable, or if the remaining useful life is greater than 25 years, an association is not required to reserve replacement costs for those items. However, the association must reserve the amount of deferred maintenance expense, if any, which is recommended by the Structural Integrity Reserve Study for those items. So in this particular case, we're not necessarily concerned so much about the replacement costs of these items that are not easily ascertainable or that have a very long useful life. We're more concerned with the maintenance costs of those items. And we'll touch a little bit about on waiving and reducing reserves. So for those non-CEUs reserves, so those things outside of that are listed there, the little g items in 718.112, the members, again, of a unit owner controlled association, meaning not under developer control, may determine by a majority vote of the total voting interests of the association to provide no reserves or less reserves than required by statute. So again, that takes a majority vote of the total voting interest, i.e. all of the members. Now, specifically for CEUs reserves, for a budget that's adopted on or after December 31st of 2024, those members that live in a unit owner controlled association that must attain a structural integrity reserve study may not determine to provide no reserves or less reserves than required by statute for the structural integrity reserve study items. But there's an exception, and this is a very narrow exception. Except for members of an association operating a multi-condominium may determine to provide no reserves or less reserves than required by statute if an alternate funding method has been approved by the division. Now, even more specifically, these alternate funding methods, they really apply to a multi-condominium association that operates at least 25 condominiums. And if you're part of such association, you know who you are. And really the carve out here, excuse me, it really is to address the capital expenditures and deferred maintenance in a way that aligns with the specific circumstances and budgets that occur in these multi-condominium associations. But for everybody else, you do not get that option of waiving or reducing. And then the ability to use reserves for a different purpose. So for those non-CEUs reserves, reserve funds and any interest accruing thereon must remain in the reserve account or accounts and may only be used for authorized reserve expenditures unless they're used for other purposes as approved in advance by a majority of all the voting interests. And again, that's a majority of all owners. Now, for a budget that's adopted, and this portion is for the CEUs reserves, for a budget adopted on or after December 31st, 2024, members of a unit owner controlled association that must obtain a structural integrity reserve study may not vote to use reserve funds or any interest accruing for any other purpose other than the replacement or deferred maintenance costs of the structural integrity reserve study items. So there's a limitation there. And then we'll very briefly touch on pooling. And I provide this kind of red flag warning because this is not in the Florida statutes. And I will tell you up front that different attorneys in different firms have different views. There's that old adage that if you ask two attorneys the same question, you'll get three different answers. Well, this is one of the areas that attorneys may disagree. So when we talk about pooling, we're talking about putting everything into that same pool. So generally, pooling of existing line items reserves requires approval of a majority of all the total voting interests. not a majority of a quorum that may be present at a meeting. And then if the association is going to pool, we suggest that not pooling the structural integrity reserve study items with any other items. In other words, keep those CEUs items segregated. And then, of course, we've got the disclaimer, check with legal counsel, because opinions do vary on this. And it is very possible that your particular association counsel may have a differing opinion. I want to touch a little bit on local government intervention. And these laws went into effect on July 1st of 2024. If the local building official determines that the entire condominium building is uninhabitable due to a natural emergency, hurricane, flood, drought, earthquake, or otherwise, the board, upon approval of a majority of the members, may pause the contributions to the reserves or reduce reserve funding until the local building official determines the building is habitable. Any reserve account funds held by the association may be expended pursuant to the board's determination. So that's important to know. This is a board decision using the board's reasonable business judgment to use those funds to make the condominium building and its structures habitable. And then upon the determination of the local building official that the condo building is habitable, the association must, again, immediately resume contributing funds to the reserve. And then finally, we get to milestone inspection and CEUs. Oh goodness, what else? Well, you know what? There's that famous saying, there's always more. And in this particular case, we'll touch a little bit on developer. So notwithstanding when the certificate of occupancy was issued or the height of the building, a developer must include with the turnover inspection report the structural integrity reserve study that attests to the required maintenance, condition, useful life, and replacement costs of the following. And again, you see those items that are laid out in 718.112. However, there seems to be a bullet point missing because it does not apply to developers, and that is those items that cost $10,000 or more. So notice that there is that particular item missing, but all of the other items are here. And then we have unit owner disclosure requirements to prospective purchasers. So if any of you are or know anybody who is selling their unit, each contract for the sale of a residential unit that's entered into after December 31st of 2024 must contain in conspicuous type certain disclosures regarding the milestone inspection or the structural integrity of reserve studies. A contract does not conform to those disclosure requirements is voidable at the option of the purchaser prior to closing. So it's not automatically void, but it is voidable, cancelable at the option of the purchaser. And then if an association is not required to have a milestone inspection or a structural integrity reserve study, each contract for the sale of a unit that's entered into after December 31st, 2024 must contain in conspicuous type a statement indicating that the association is not required to have that milestone inspection or a CEUs reserve study as appropriate. And conversely, if the association is required to perform a milestone inspection or a structural integrity reserve study, and first bullet point here, has not completed the inspection or the reserve study, each contract for the sale of a residential unit that's entered into after that December 31st, 2024 date must contain in conspicuous type a statement indicating that the association is required to have that milestone inspection or a structural integrity reserve study, but has not completed such inspection or study. And conversely, if the association has completed a milestone inspection or a structural integrity reserve study, each contract for the sale of a residential unit entered into after that December 31st, 2024 date, again, must contain in conspicuous type the disclosures that are set out in Chapter 718.533. And then each prospective purchaser who has entered into a contract for the purchase of a condo unit is entitled, and this is at the seller's expense, to a current copy of the inspector prepared summary of that milestone inspection report and the association's most recent structural integrity reserve study. After the reports are provided, the buyer has a 3-day business days to cancel the contract upon written notice to the seller. So there is, interestingly enough, a cooling off period here of 3 business days. And then the right to void the contract cannot be waived. And then finally, disputes regarding milestone inspection and CEUs. And this is coming up to be effective on July 1st, 2027. And literally what this is doing, this is broadening the term of what dispute actually means and subjecting it to pre-suit mediation. So the term dispute is eventually going to include the failure to obtain the milestone inspection report that's required under section 553.899, the failure to obtain a structural integrity reserve study that's required under 718.112, the failure to fund reserves is required, the failure to make or provide necessary maintenance or repairs of the condominium property that is recommended by the milestone inspection or the structural integrity reserve study. And again, these particular items, they're not subject to mandatory non-binding arbitration, but rather they're going to be submitted to pre-suit mediation. And then if pre-suit mediation is an impasse or is unresolved, then litigation can ensue. So ladies and gentlemen, that is my portion of the project. Hopefully we have met our time requirements, and I'll turn it back over to Jeff.
Well done, sir. Well done. Peter has joined us. We'll introduce him in a second. Now is a good time if you want to take a quick bio break or get a drink, go do that. Come on back. Ben, do you want to look through the Q&A real quick just to see if there's one or two you want to get before we start Peter's section, topic 2?
Sure. Let me get here.
And folks, while Ben is looking, we're only going to do a couple of questions. That's it, because we really want to move on and get you out of here. We know nobody wants to be here for 4 hours, so we want to get this done as quickly as possible. So Ben will take a couple of the questions. While he's looking at the couple of questions to answer, if you haven't already done so, press the chat button one time, simply so it appears on your Zoom interface. Don't worry, it will say your chat is disabled. There's nothing for you to enable. That we can still send stuff your way. And later on, that's where we're going to place the required evaluation link. And one other thing I want to quickly mention too, this is still coming up in the Q&A. You do not need to type in asking me, hey, can you see me? Am I here? Your links that you got after you registered, they're tied in to your registration information. So by clicking on that link and joining, we know you're here. No need to ask us. Okay, Ben, back to you for a couple of questions.
All right, as I'm just scrolling through here real quick, we had a question here. What is considered habitable 3-story building? Well, that's the subject of the Florida Building Code. And generally, habitable means, hey, an individual can live, right? So we're not talking about the non-unit portions of the building. We're not talking about garage areas or things of that. We're actually talking about the habitable areas as far as living spaces.
Okay, let's do one more, and then we'll get over to Peter.
Sure. Next one I see, we are in a 2-story building. Any chance that rules might eventually include 2 stories? Good question. Don't know. Is it possible? Yes. And if and when that happens, we will certainly keep all of you updated. So thanks so much, everybody.
Thank you, Ben. And we know you're going to hang out and watch, so chime in if you have anything to add a little bit later. Good job. Well done. And we want to now introduce one of Ben's colleagues also over in the Palm Beach Gardens office, Peter Mullengarten, who happens to be one of the few, there aren't that many in the state of Florida, a board certified specialist in condo and plan development law. And Peter is one of those. Peter, how are you, man? How was breakfast?
I'm well. I was speaking, I wasn't eating, so No breakfast for me.
Oh man. All right, let me get the next section up there. Can you see it?
I can see it. Very good.
Wonderful. So Peter's going to cover elections and official records and record keeping as we continue on. And folks, yes, if you have to switch from one device to another, or if your technology kicks you off, just make every effort to come back on. We can see the Zoom timestamps. If you leave for a half an hour and come back, that's another story. You're probably not going to get your certificate. So don't worry about that. We can see when you're making the effort. Peter, elections. Here we go.
Okay. Hi, everybody. In this marathon session and tag team session, I am up number two, or I am second at bat. So as Jeff said, I'm going to be discussing elections and inspection of records and official records and some other things. So I know it's long, so let's get started. Okay, when does an association need an election? An election is required when you have a vacancy on the board, which is caused by the expiration of a director's term. And that must be filled by electing a new board member. And as I'm sure we all know, that happens at the association's annual meeting. Okay. A vacancy that occurs before the expiration of a term, for example, by the resignation or death or the disqualification of a director, okay, other than recall, now that's filled by, unless the bylaws provide otherwise, a vote of a majority of the remaining board members, even if it's less than a quorum, or even if it's just one remaining director. Some bylaws provide otherwise, but not too frequently. Or the board has the option of calling an election. In my experience, 99.9% of the time, those type of vacancies are filled by the appointment through the remaining board members. Now, what is a timeline for elections? In condominium associations, elections are governed almost entirely by statute. So the statute generally overrules your bylaws with respect to the procedure. So what do? First thing is not less than 60 days before the date of the election, again, typically the annual meeting, the association must mail, deliver, or electronically transmit to each owner entitled to vote a first notice of the date of the election. I will mention here, and I might mention it again, as far as electronic transmission of notice, that really is only permitted to those owners who have agreed in writing with the association to receive their notices by electronic transmission. And typically that's email. Could be facsimile for an old guy like me, but generally speaking, these days it's just by email. But again, the owner has to agree. Now, any owner or other eligible person desiring to be a candidate for the board, and we'll talk about who's eligible to run shortly, must give written notice to the association not less than 40 days before a scheduled election. And I want to also state here off the outline that this is a strictly enforced provision, and the burden of proving that intent, that written intent to be a candidate was received timely, the burden's on the owner or other eligible person submitting that. And there's a couple arbitration cases where an owner, one of them slid their notice under the door of the office and swore it was delivered at 11:59 the night before, and another one gave it to a security guard. In both cases, those people were not allowed to run for the board because they could not prove that they had their intent timely delivered. So that's why the division, they recommend that be sent by certified mail, so you get a receipt, or by hand delivery, where you also get a receipt. Anyway, so next, so you get your 60-day notice, your 40-day time period to get your intent in. Then every candidate who has timely submitted their intent, they have the option to submit what's known as an information sheet. Some people call it a resume. It has other names, but technically under the law, it's called an information sheet. Not less than 35 days before the election. So again, there's a 5-day window between when they submit their intent, although you can submit it at the same time. There's a 5-day period to submit this information sheet. It must be no larger than 8.5 by 11 on one side of the paper. The cost of sending that will be borne by the association. And I also want to mention here, though it's not in the outline, that the association cannot alter, modify, change, or do anything to those information sheets. Even if you don't like what the person says, I got calls in the past about, someone submitted an information sheet and it was horrible and said terrible things about everybody, well, that's on the head of the person submitting it. The association cannot alter these information sheets if they're timely submitted. Finally, not less than 14 days, nor more than 34 days before the annual meeting and election, the association must send out the written notice and agenda, that second notice, and the second notice of the election to the owners entitled to vote, together with a ballot that lists all candidates alphabetically. And that second notice must also include all information sheets that were timely delivered. If the information sheets are not included with that second notice, that's actually a fatal flaw or a fatal error in the election process. Okay. How many directors? Typically, your bylaws will indicate how many members are on the board or how many people serve on the board. Unless otherwise provided, though, the default is the board consists of 5 directors or 5 members, except if you have 5 or fewer units, then in that event, the board has to consist of at least 3 people or 3 members. Everyone serves a 1-year term unless, under your documents, you have a staggered board, for example, or maybe you just have a board that serves multiple year terms. But typically, if you have multi-year terms, like 2-year terms or 3-year terms, you will have a staggered board in which every other year or perhaps every 3 years, electors, board members are elected for, let's say, a 2 or 3-year term. Other than that, though, they serve 1-year terms again, unless the bylaws provide that they have multi-year terms. Also, in the event all the directors' terms are expiring, but there are no candidates, then the current directors, their term will continue beyond the 1 year. Term limits. This got a lot of talk in the last few years. Went back and forth in the law. The current status of the law on this is that a director cannot serve more than 8 consecutive years, unless there is exceptions, unless that director was elected by 2/3 of all votes cast in the election. That's not 2/3 of all the votes of all the owners, but 2/3 of all the votes that were actually cast in the election. Or if there aren't enough eligible candidates to fill the vacancies, that also is an exception to the 8-year term limit. That 8-year term limit commenced counting on or after July 1st, 2018. So we're coming up on that in 2026. But yeah, the counting of the 8 years begins July 1, 2018. Who's eligible to serve? Okay. The law was changed a few years ago to provide that in a residential condo that has more than 10 units, co-owners of a unit, husband, wife, brother, sisters, whatever, co-owners of a unit cannot serve as directors at the same time unless they own more than 1 unit or there's not enough eligible candidates to fill the vacancies. There's also election by acclamation. So if you have, if the number of vacancies equals or exceeds the number of candidates, no election is required, and those eligible candidates are automatically on the board because there is no contested election. For example, 5-person board, and you have 5 or fewer candidates, they're automatically elected. Quorum, and this is very important. I got a call about this yesterday, in fact, from one of my clients. There is no quorum requirement for the election of directors, except the quorum requirement, if you want to call that, is at least 20% of the eligible voters must cast a ballot in order to have a valid election. So that's a pretty low percentage. 20% of your electorate, in essence, must cast a ballot, and that constitutes a quorum for election. However, even though it's not on the slide here, however, if you're doing other things at the annual meeting, for example, you're having an election, but you're also voting on amendments, or you're voting on a material alteration, those other issues will need a quorum, okay? But the election does not need a quorum. It just needs 20% of the eligible voters voting. All right. Elections are decided by a plurality of the votes cast. That is, who gets the most votes. You don't have to get a majority of all the votes in the condominium, but you have to get a plurality or the most votes of those votes being cast. What about all your election material? The ballot, sign-in sheets, voting proxies. That's a bad name for it because really don't have a voting proxy, but that is in the statute. And all other papers related to voting by owners Actually, it is voting proxies if you're voting on something other than an election. So it is proper. All that must be maintained for a period of at least 1 year from the date of the election, vote, or meeting. So anything dealing with voting, elections, voting or otherwise, maintain all those documents, sign-in sheets, ballots, proxy votes for 1 year. Also, any challenge to the election process must be commenced within 60 days after the election results are announced, typically at that meeting. So I always kid around saying that if you do everything wrong and you mess it up totally, but more than 60 days elapsed, then you've done, I guess, everything right because the time period the challenge has run. Okay, who's eligible to serve on the board? I've run into a lot of kind of myth on this where people, I think, for whatever reason, feel that the only people who are eligible to serve on the board are owners or members of the association. That's true if your documents, generally your bylaws and articles of incorporation, limit the people on the board to being owners or being members. But if they don't limit it, then technically anyone 18 years of age or greater that lives in the state of Florida can serve on the board. So all owners are eligible unless they're excluded for certain reasons that we're going to get to. Non-owners, they can run for the board too if your bylaws or if your articles or declaration so allow. Okay. Any person desiring to be a candidate must be eligible to be a candidate to serve on the board as of the deadline to submit your name. Remember that 40-day deadline, not less than 40 days before the meeting. Okay, that's the deadline in which you must be eligible in order you're not eligible. Any person who is delinquent in the payment of any assessment to the association as of that deadline to submit your intent, okay, is not eligible. So even if that person becomes current, let's say on the 39th day, it's too late. Okay, they have to be current with all their assessment payment. Now, this used to say delinquent in any monetary obligation, but it was changed a couple of years ago to say delinquent in the payment of any assessment. Also, any person who's been suspended or removed by the division under the Condominium Act is also not eligible to be a candidate. Furthermore, anyone who has been convicted of a felony or has been convicted of any offense in another state, which would be considered a felony if committed in Florida, is not eligible for board membership unless that person's civil rights, for example, right to vote, right to hold public office, serve on a jury, etc., have been restored for at least 5 years as of the date that that person seeks election to the board. The validity, though, of an action by the board is not affected if it is later determined that someone who was serving on the board was not actually eligible at that time. So they're not going to strike out or overrule actions taken by the board, even if one or more members of the board at that time was actually not eligible. Also, if there's a criminal charge pending against an officer or director, for example, forgery of a ballot, theft or embezzlement of association funds, obstruction of justice. Again, these are just charges, not conviction, but just if you've been arrested or indicted, etc. That person may not be appointed or elected to the position as an officer or director of any association and may not have access to official records of any association except pursuant to a court order until those charges have been dismissed. Secret ballot. In condominium elections, you cannot vote by proxy, okay? So a proxy, limited or general, cannot be used in the election of board members. You have to vote by secret ballot method. If you're doing it by the paper method and not by electronic voting, then it's cast, those election ballots are cast pursuant to an inner envelope, which holds the ballot, and an outer envelope, okay, addressed to the person authorized to receive the ballot. The exterior of that envelope, once it's received, must indicate the name of the voter, indicate the unit or unit address, and contain a signature space for the voter that he or she must actually sign. The inner envelope, which contains the ballot, can only contain one ballot. If someone is entitled to cast more than one ballot, for example, I own multiple units, I own 2, 3, whatever, 4 units, then I can include separate inner envelopes for each of my units, but they may be enclosed within a single outer envelope. As I mentioned, the voter must sign the exterior of the outer envelope in the space provided for that signature, and then either mail or hand deliver the ballot back to the association. This is really important. Upon receipt by the association, no ballot may be rescinded or changed. So if someone submits a ballot, we've received it, the annual meeting is still X days away, and they come run up and say, I messed up, I want my ballot back. No, it's too late. Once we've received someone's ballot, it cannot be changed or cannot be rescinded. An owner cannot authorize any other person to vote his or her ballot, and any ballots that are cast like that are invalid. And a unit owner who violates that provision may be fined by the association. The only exception here is an owner who needs assistance in voting or casting his or her ballot because of disability, blindness, inability to read, etc. That person may obtain assistance in completing and casting their ballot. Now, verifying the outer envelope. So we've got the envelopes back, the outer envelopes, right? Then what happens? And that now the association has to verify the information that's on the outer envelope. I mentioned before, the unit number, address, and the signature. That verification is done by an impartial committee consisting of members of the association who are not current board members, officers, candidates, or any of their spouses. Now that committee meeting or election committee meeting, that can be held on the same day as the annual meeting, but earlier in the day. That meeting must be noticed just like a board meeting with 48 hours posted notice. It's open to all the owners. It's open to all the members. Like I said, it must be, you must post notice of it 48 hours in advance and on the same day. If you don't have that election committee verification meeting on the same day, then it's done at the annual meeting in front of the membership, typically at the front of the room where everyone can observe. So it's either done on the same day, but early in the day with a 48-hour posted notice, or it's done at the annual meeting as basically the first order of business is would be the verification of the outer envelopes by that committee. The signature and the unit ID on the outer envelope must be checked by the committee against the list of qualified voters, okay? And they check off, that unit has voted, that there's been a ballot cast. Obviously, they don't know what the vote is at this point because they haven't been opened yet, because all this is done before any ballot envelope is opened. This is just the verification of the actual outer envelopes. Any outer envelope that's not signed by the eligible voter for that unit must be marked disregarded on the outside, or words of similar import, and any ballots contained there must not be counted. Now, it doesn't get thrown away and it doesn't get opened. So those that are being disregarded are put to the side and not counted. Ben, do you have something? Okay. Jeff, I lost the feed. A technical glitch.
Yeah, Peter, I think we actually lost Jeff too.
Ah. Okay.
We'll blame it on one of those rare Florida snowstorms.
That is correct. Oh, I just got a text. He lost power and he's rebooting.
Ah. So I
So
guess it's up to us to practice our comedy routine.
I'm going to sing a song now, and that should empty the Zoom pretty quickly. All right. Well, hopefully we will be back online shortly.
If you guys would, I think what we could probably do, we have a bunch of questions in the chat. So possibly maybe there's some questions that we could run through while Jeff is.
Yeah, sure. If you can repeat them, since I see nothing.
Certainly. I'm gonna scroll to some of the most recent ones. Let's see. So this one is from Raymond. We have staggered 2-year terms, and our annual meeting and election is February of every year. If a board member was already on the board July of 2018 and they run again this year and are elected in February, 5 months before July, but not by the required percentage of votes, can they still fulfill their 2-year term, or would they need to step down?
You know what? I was thinking about that actually today. And I'm not sure, but my gut reaction would be that they may have to step down when that 8-year time period came. Because that's, it doesn't really address that. It's an interesting question. I don't have a great answer for it because, statute does say that you can't serve more than 8 consecutive years. And it would seem to me, although they could be elected, I'm not sure what happens in the midterm. My gut reaction would be that their time would expire by operation of law. But I haven't had it happen yet. So it's a great question.
All right, so we have another one. So what if a person wants to be on the ballot for the board, but they have pleaded no contest to a felony?
If that counts as a conviction of a felon, then they couldn't serve. I know that withheld adjudication is not deemed to be guilt. No contest may. That's something I always have to look at to see, what is the classification as a conviction. So assuming that is equivalent to a conviction, they're not eligible.
Gotcha. So it looks like we have a bunch of questions. I'm going to jump back to them in regards to term limits. So if a person is on the board for 7 years and they don't run for the board on the 8th year, then the following year they run and get elected again. Does that mean they have another 8 years to be on the board?
That's fine. It has to be 8 consecutive years. So if you're on 7 and go off and then come back on, you're okay. You start the count again.
Excellent. So here's an interesting one. If you have one or more board members who have not taken the required 4-hour certification course, how long are they allowed to remain as an inactive board member?
Well, they're not really inactive. They're off. I mean, if you haven't done this, you're suspended until you've become certified. And the board can appoint someone to fill that vacancy, that temporary vacancy, until you do get certified, and then you're back on. So it's a temporary suspension for as long as the person is not in compliance with the certification requirements.
Excellent. So here's a loaded one, Peter. I'm going to throw this one at you.
I want the power to come back on. No, go ahead.
Question is, we have issues with owner participation. What are your thoughts on virtual voting?
Well, my thought is you can adopt electronic voting. Okay. So, and that's part of my presentation if we ever get this thing cranked up again. So yes, I think when you say virtual voting, the Condominium Act does contemplate voting electronically if the board adopts that procedure. So that's what I would suggest for that type of association. That way you'll get more people participating by sitting in their underwear at home and clicking the mouse. Okay.
Gotcha. So Jeff, welcome back.
Sorry about that, folks. Technology is great when it works. We do have some inclement weather where I am located. Peter, what's the slide page number? Well, let's see here. Is that all close?
We were on the election. I don't know the number.
I'm getting there. Yeah.
We were just talking about the outer envelope verification process.
Okay.
Disregarding ones that were messed up.
Ballot.
For lack of a better term, messed up is what I'll say today. That were not proper, improperly completed.
Let's see here. Share.
Peter and I didn't have to resort to our improv and karaoke skills.
Yeah, I was going to do some.
Going.
I was going to do some stand up or sit down, but
does this look right?
Yes.
Okay.
Thank you for getting us back.
And,
my last point on this slide is those disregarded ballots, if I didn't mention this before, must be kept, must not be opened, and kept as part of the records. Okay. Fraudulent voting activities. A person who engages in a fraudulent voting activity, just by the nature of that phrase, commits a first-degree misdemeanor, And that could include using threats against people, bribery, or intimidation related to someone voting or casting their ballot. Forgery of a ballot envelope or voting certificate used in a condominium association election is punishable as a third-degree felony. Electronic voting, and this is a question that we just had during our impromptu improvised break. An association may use an online electronic voting system for all owner votes, which includes elections, if an owner consents electronically or in writing to online voting, which is valid until the owner opts out of online voting. There's a method to get that. We'll get that in a second. An owner voting electronically is counted as being in attendance for purposes of a quorum. The use of electronic voting must be established by a board resolution made at a board meeting. Notice at least 14 days. Notice that 14-day notice for this type of board meeting, which is different than typical board meeting. So the meeting must be noticed at least 14 days before the meeting by mail, delivery, or again, electronic transmission, and posted on the condominium property, evidenced by affidavit. So the notice of the board meeting, when the board's going to adopt electronic voting as a voting method, is a 14-day board meeting notice sent to all the owners and posted 14 days in advance, with the person sending that notice and posting it on behalf of the association signing an affidavit that the 14-day notice requirements were met. Okay, that board resolution adopted at that meeting must provide that the owners will receive notice of the opportunity to vote through an online voting system, must establish reasonable procedures and deadlines for owners to provide their written consent, and establish reasonable procedures and deadlines for owners to opt out of the online voting. But once you've opted in, you're in until you opt out. Okay, if online voting is used, the association must give each or provide each owner with a method to authenticate the owner's identity, must ensure the secrecy and integrity of election ballots, and a method to confirm at least 14 days before the voting deadline that the owner's electronic device can successfully communicate with the online voting system. Okay, the association must use an online system that is able to authenticate, again, the owner's identity, authenticate the validity of each electronic vote to ensure that the vote wasn't altered in transit, transmit a receipt to each owner who cast an online vote or cast a vote via online, and permanently separate any authentication or identifying information from the electronic election ballot. Because remember, election ballot still must be secret, rendering it impossible to tie an election ballot to a specific owner. Store and keep electronic votes accessible to election officials for recount, inspection, and review purposes. Now, that's all sounds pretty complicated, right? It goes, oh my God, how are we going to do all that? Generally speaking, the companies that sell the software, they manage it through their software package to meet all these criteria. So if you're going to do electronic voting, the software package that you buy or acquire will be able to, do all these, or meet all these requirements. Okay. If the board does jump through the hoops and have the meeting to authorize electronic online voting, the first notice of the date of the election must disclose, if you're, after you've adopted online voting, must disclose the procedure and deadline to consent to electronic voting in that 60-day notice of the election. If the board authorizes online voting, the board must honor an owner's request to vote electronically at all subsequent elections unless the owner opts out of online voting. A vote of the owners may not be taken on any issue other than the issue specifically identified in the electronic vote. So the owners in person at the meeting can't be raising their hands and making motions to vote on things that the online voters, aren't there for. So basically, your agenda and your voting matters are limited to what the online voters plus the people voting in person, or if it's not an election by proxy, what they're voting on. Officers. So we talked about the election of directors. Okay. Officers, very, very different. Okay. And some people get the two, they conflate the two, and they should not. Okay. Unless otherwise provided in the bylaws, a board must have a president, a secretary, and a treasurer. And they do, as those officers customly do their duties. Unless prohibited by your bylaws, the board may appoint other officers and grant them the duties as it deems appropriate. Now, unless otherwise provided in the bylaws, the officers serve without compensation. Sorry out there. and they serve at the pleasure of the board, or I should probably say displeasure. And I want to stop here for 1 second. Generally speaking, officers, unless the bylaws are somewhat unusual, officers can be removed from their office pretty much at whim by the board. It doesn't mean they're removed from the board, though. So if the board doesn't like the job, let's say the president's doing, or the vice president, the treasurer, whoever, they can have a board meeting and switch out who's president, who's treasurer, who's secretary, whatever, but they're still on the board, okay? So the board can't basically throw off or unelect board members, but they can change officer positions if they want, unless the bylaws have some unusual provision. Okay. Typically, officers are elected by the board immediately following the election of directors. By the way, that is an open board meeting. Okay. I know I've seen many times where, the board, they will adjourn themselves to some back room, closed off, and do their officer election. No, that meeting is open. It's in front of the owners, and it should be noticed, quite frankly, like any other board meeting with a 48-hour posted notice. However, although it's an open meeting, this is the only time that directors can vote by secret ballot. Okay, you can't vote by proxy, okay, but you can vote by secret ballot for the election of officers. Okay, and that's the only time. And as I said, the last bullet point there is no prohibition against changing officers midterm. Just keep in mind, changing officers does not mean you're changing who's on the board. All right. So once you're on the board, how can you be disqualified from serving on the board? Okay, other than disqualified by, say, not owning a unit any longer if your documents require directors to be owners. Okay, if an officer or a director knowingly solicits, offers to accept, or accepts a kickback, all right, that person commits a third-degree felony, is subject to a civil penalty, and must be removed from office and a vacancy declared. What is a kickback? Well, we all pretty much know this, but a kickback means anything or service of value for which consideration has not been provided for the person's own benefit or that of his or her immediate family from any person providing or proposing to provide goods or services to the association. So someone can't give you a bag of money, in other words, to then become the painter for the building or something like that. That's pretty obvious. That's a kickback. An officer or director charged, not convicted, but just charged by information or indictment for any crime set forth in 718.1122Q, which, for example, forgery of a ballot, theft or embezzlement of association funds, obstruction of justice, is removed from office. If the charges are resolved without a finding of guilt, then that officer or director must be reinstated for any period of the term that's still remaining. Okay. Finally, though, that's a temporary throwing off the board until those charges are dropped. But if an officer or director is more than 90 days delinquent in the payment of any monetary obligation, remember before we talked about being delinquent in the payment of an assessment to be eligible to run for the board? Well, once you're on the board, if you're more than 90 days delinquent in the payment of any monetary obligation, that would include an assessment, a fine, or any other monetary obligation, then that person is deemed to have abandoned his or her seat on the board, and that vacancy is filled. That's not a temporary vacancy. That means that person's off the board. They're off the board, and then the board fills that vacancy. Other ways that you can be disqualified. If you knowingly and willfully violate the official records inspection requirements 2 or more times, and we're going to talk about official records in a few minutes, 2 or more times within a 12-month period, that person commits a second-degree misdemeanor and must be removed from office and a vacancy declared. Any person who knowingly or intentionally defaces or destroys accounting records, and we're going to talk about that too, required to be maintained during the period for which such records are required to be maintained, or who knowingly or intentionally fails to create or maintain accounting records that are required to be created or maintained with the intent of causing harm to the association or one or more of its members, commits a first-degree misdemeanor, is personally subject to a civil penalty, and also is removed from the board, or removed from office, either the officer or as a director or both. A person who willfully and knowingly, so all these are willfully and knowingly, okay? A person who willfully and knowingly refuses to release or otherwise produce association records with the intent to avoid or escape detection, arrest, trial, or punishment for the commission of a crime, or to assist other persons or another person with such avoidance or escape, he or she commits a third-degree felony and is also removed from office and a vacancy created. Debit cards, this is kind of interesting, okay? A person who uses a debit card issued in the name of the association or billed directly to the association for any expense that is not, in quotes, a lawful obligation of the association commits theft and must be removed from office and a vacancy declared. What's a lawful obligation of the association? That means an obligation that has been properly pre-approved by the board and is reflected in the meeting minutes or the written budget. If the board finds that an officer or director has violated the conflict of interest requirements, that person is also removed from office, creating a vacancy to be filled. In other words, they haven't disclosed a conflict that they have with, say, a company that the association is dealing with. They haven't disclosed that they have a financial interest, let's say, in the landscape company or the painting company or whatever. That's a conflict of interest, which must be disclosed and must be approved through all sorts of things. There's a bunch of hoops you got to jump through to approve that type of contract or transaction. So if that person has not, disclosed that type of conflict, then they're removed from the office. Finally, a director who fails to timely file the written certification and education certificate, i.e. what we're doing today, is suspended from service on the board until he or she complies with the requirement. I answered that question during our break, in an impromptu break. Failure to have that written certification, educational certificate on file does not affect the validity of any board action. So if certain board members, are not certified, did not become certified, the actions the board took while he or she was on the board are not invalid just because they were not certified at that time. Websites. Okay. An association having 150 or more units must create a website or an app, and we'll get to that in a second, for the posting of association documents, and that website must be operational on or before January 1, 2019. Now, importantly though, effective January 1st, 2026, so 7 months or 6-7 months from now, the website requirement will apply to an association with 25 or more units, which is pretty low. So, the vast majority of associations will have to have a website effective the beginning of next year. The association's website must be an independent website or web portal, wholly owned and operated by the association, or a website or web portal operated by a third-party provider with whom the association owns, leases, rents, or otherwise obtains the right to operate a web page, subpage, web portal, or collection of subpages or web portals, dedicated to the association's activities and on which required notices, records, and documents may be posted by the association. So what else about the website? Well, it has to be accessible, obviously, through the internet, must have a subpage, web portal, or other protected electronic location that's not accessible to the public and accessible only to owners and employees, and they must be provided a username and a password and access to the protected sections of the website, and that contain any notices, records, or documents that must be electronically provided. What has to be on this website? Well, all of your governing documents, your declaration, bylaws, and all the amendments, your articles of incorporation as filed with the Florida Department of State, or other documents creating the association. That's usually the articles of incorporation, though. All the amendments to those as well, and your rules, your current rules of the association. That all must be posted. In addition, a list of all executory contracts, a contract to be performed, or documents to which the association is a party, or under which the association or the owners have an obligation or responsibility. And in addition, after bidding for certain materials, equipment, or services is closed, a list of bids received by the association within the past year. Now, you can post summaries of bids for materials, equipment, or services which exceed $500, must be maintained on the website for 1 year, or in lieu of summaries, the complete copies of the bids may be posted. Probably suggest post the entire bid, quite frankly. What else goes on the website? The annual budget and any proposed budget to be considered at the annual meeting. A little unusual because usually the annual meeting is a member meeting and usually budgets are adopted by the board. Nevertheless, just be aware that if a budget is going to be proposed or adopted at an annual meeting, it must be posted. The financial report and any proposed financial report to be considered at a meeting, your annual financial report, the certifications of each director, again, what we're doing today, all contracts or transactions between the association and any director, officer, corporation, firm, or an association that is not an affiliated condominium association, or any other entity in which an association director is also a director, officer, and financially interested. Again, all these conflict of interest type transactions. Any contract or document regarding conflict of interest or possible conflict of interest. Those two are related. Also, notice of any board meeting, the agenda of the board meeting, and any other document required for the meeting, that must be posted no later than the date required for the notice. So if it's a 48-hour type board meeting posting, it must be on the website 48 hours in advance. If it's, say, a special assessment meeting where the notice is 14 days in advance, then it has to be posted 14 days in advance. Now, what about unit owner meetings? Well, the notice of any unit owner meeting and the agenda must be posted on the website not later than 14 days before the meeting. The notice must be posted in a plain view on the front page of the website or app, or on a separate subpage of the website or app labeled Notices, which is conspicuously visible and linked from the front page. The association must also post on the website or app any document to be considered and voted on by owners at an ownership meeting, okay, or any document listed on the agenda of an ownership meeting at least 7 days before the meeting at which the document or the information in the document or within the document will be considered. Now, I know you guys were talking about structural integrity reserve studies. Well, the most recent structural integrity reserve study, as well as all inspection reports, which would be milestone inspection reports or any other structural report related to the structural or life safety of the condominium property, must also be posted on the website. Copies of all building permits issued for any ongoing or planned construction. The failure to post these requirements on the website does not in and of itself invalidate any action or decision of the association, of the board, or of the owners. Each association is required to designate on its website a person or entity with a street or email address for receipt of a request for an estoppel certificate, which is issued pursuant to the Condominium Act. The association must ensure that the information and records that are not accessible to owners are not posted on the website. And we'll talk about what those inaccessible records are in a few minutes. If protected information or information restricted from being accessible to owners is included in documents that are required to be posted on the website, the association must ensure the information is redacted. So if you inadvertently included information that is not accessible on documents that you were required to post, then you must redact them from those documents. However, there is no liability for disclosing information that is protected or restricted unless it was made with a knowing or intentional disregard of the protected or restricted nature of that information. As I mentioned a few times, instead of posting the required documents and information on a website, an association can instead make them available through an application that can be downloaded on a mobile device. That app must meet all other requirements imposed on a website pursuant to the Condominium Act. Official records, very important. The Condominium Act, Section 718.1111, subsection 11, if I got that right. There's a list of what comprises the official records. And I'll read this relatively quickly, but it's all the plans, permits, warranties, and other items that were received by or from the developer. All your recorded documents, meaning the declaration, bylaws, and all amendments, and a copy of your current rules. Okay. The articles of incorporation and all amendments to that. Meeting minutes, and that's meeting minutes both of board meetings and membership or owner meetings. Number 5, crucially important, a current roster of all owners, their mailing addresses, the unit identification, in other words, the unit numbers, voting certificates, if any, and if known, telephone numbers. Although interestingly, telephone numbers are privileged, and we'll get to that in a second. The association must also maintain and make available for inspection the email addresses, excuse me, of those owners who either consented to receive notice of association meetings via email or expressly indicated that the email can be shared with other owners. I'll stop here for a second. Email addresses of owners that you may have, they're privileged and not accessible to other owners unless that owner has agreed to make it accessible, again, in writing, or has agreed, again, in writing, that that email address is their official address to receive association notices, meeting notices, for example. Also, emails may only be used for the business operation of the association and may not be sold or shared with outside parties. I'll stop here for 1 second. In my experience with these long-term cable TV contracts, they often want you to provide them with all the email addresses. And I always object to this because the association is not, cannot, is not authorized to share those email addresses with outside parties, including, in my opinion, any company who wants to provide long-term or bulk cable service or internet service. Okay, going on. All the current insurance policies, your financial records, for example, audits, reviews, account statements, and financial records, actually anything that has anything to do with the financial operation of the association that you have in your possession, that's a financial record. Accounting records, and now these must include, without limit, records of all receipts and expenditures of the association, invoices, transaction receipts, or deposit slips that substantiate any receipt or expenditure of funds, and current account and a monthly, bi-monthly, or quarterly statement of account for each unit, showing the name of the owner, the due date and amount of each assessment, the amount paid on the account, and the balance due. And just, I'll stop here for 1 second. That third item about every owner's account balance and their status, that's not privileged, okay? If owners want to see the account history of other owners, they can. Now, if any confidential information happens to be on that document, like personal identification information, social security number, driver's license, that kind of stuff must be redacted. But the actual financial record or history of that person, that's not privileged. Okay, next. Moving on, any management agreement, lease, or other contract in which the associate is a party is an official record. Any kind of contract in which the members have an obligation or responsibility. Bill of sale, or transfer for all property owned by the association, if there is, if you have that. Voting records, we mentioned that before, but ballots, sign-in sheets, voting proxy, and all their papers, they must be maintained. They must be maintained for at least a year. All rental records, if the association is acting as an agent for the rental of units. A copy of the current question and answer sheet, which is something that the Condominium Act requires. A copy of all inspection reports, whether that's milestone or other structural reports or any other report dealing with the property. All the bids for material, equipment, or services. All affirmative acknowledgements made pursuant to 718-121. What's that? That's an acknowledgement regarding how an owner will be sent basically their assessment invoices or statements about what they owe. They have to acknowledge anytime that method is changed. A copy of all building permits, the board member certificates, example from today, and the catch-all at the bottom, all other written records not specifically included in the statute that relate to the operation of the association. So it's pretty broad, obviously. Now, how long do you have to keep this stuff? At least 7 years, except for a couple of exceptions. However, there's some things you have to keep permanently, in other words, forever. The stuff that you received from your developer, plans, permits, warranties, other things. Your governing documents, the declaration, the bylaws, and the amendments, the articles of incorporation and the amendments, your rules, and all meeting minutes, again, board as well as unit owner. The structural integrity reserve study, your milestone inspection report or reports, if you have phase 1 and phase 2, they must be maintained for 15 years, and any other report regarding the structural aspects of the property. bids for work to be performed or for materials, equipment, or services to be provided. They have to be maintained for at least 1 year after receipt of the bid. And as I mentioned a few times already, all of the voting material for any kind of vote that the owners take, that must be kept for 1 year. You must maintain your records in an organized manner that facilitates inspection by an owner. So you can't just say, hey, here's a giant cardboard box of everything we got. Have fun. No, there has to be in some type of organized manner. So, that facilitates an owner's inspection of those records because they're entitled to inspect and get copies. If the records, the official records, are lost, destroyed, or otherwise unavailable, the obligation to maintain them includes a good faith obligation to obtain and recover those records as is reasonably possible. So you can't just throw up your hands and say, oh, everything's gone. We don't know where it is. Good luck. You have to try to recreate those records and make a good faith effort to. So how about owners' rights to inspect and copy the records? Well, after receipt of a written request, okay, not verbal, after receipt of a written request by the board or its designee could be the management company, for example, or the property manager, the official records must be made available to the owner and the owner's authorized representative, if the owner designates one, within 10 business days of receipt of that request. The inspection and copying must be held or conducted within 45 miles of the association, of the condominium, or within the county in which it's located. Now, renters or tenants, this is relatively new, they have a right to inspect and copy certain things, but it's just a declaration of condominium, the bylaws, rules, and the amendments to those documents, and all inspection reports that we mentioned a few times already. Now, the association has a choice or options of how it wants to comply with these inspection requirements. They can have a copy of the records available for inspection or copying at the property, okay? They can offer the owner and/or their representative the option of making the records available electronically via the internet. If official records are posted on the website or the app, they can direct the person to the app or to the website if the records that they are seeking are on the website or on the app. It can also allow the records to be viewed in electronic format on a computer screen and printed upon request of the owner. The right to inspect the records, as I mentioned, includes the right to make or obtain copies at the expense, if any, of the owner, of the member. The association must also allow a member or his or her rep to use portable device or a portable device such as a smartphone, tablet, scanner, portable scanner, or any other technology capable of scanning or taking photographs. You can't charge for that, so they're able to use their tablet, use their smartphone, use their portable scanner free of charge to make an electronic copy or photograph of the records rather than the association providing a copy of it. The association must maintain an adequate number of copies of the Declaration of Condominium, the Articles of Incorporation, bylaws, and all the amendments to those documents and the current rules, the question and answer sheet, and year-end financial information. In other words, your audit, review, compilation, whatever. You have to keep that on the condominium property to ensure that they will be available to owners and their prospective purchasers, and the association can charge its actual cost for preparing and furnishing those documents to the owners or the purchasers requesting them. Actually, it's usually through the seller. Inspection and copying checklist. This is new, or new as of last year, so it's pretty new. In response to a written request to inspect records, the association must simultaneously provide to the requester a checklist of all records made available for inspection and copying. That checklist must also identify any of the records that were not made available to the requester. You have to maintain that checklist or keep that checklist for 7 years. An association that provides a checklist pursuant to these requirements, that creates a rebuttable presumption that the association has complied with its obligations. An association, and this is, many have done this, so it's, if you haven't, you may want to do this. You can adopt reasonable rules regarding the frequency, time, location, notice, and manner of records inspection. Again, reasonable rules. However, the association cannot require an owner to show any proper purpose for the inspection or state any reason for the inspection. I'll stop here for 1 second. Throughout my career, I can't tell you how many times I've had associations, boards come to me and say, this owner is the biggest pain in the boop that we have. And they just sent us this request for record inspection. We think it's harassment, blah, 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 blah. We can't stand this person. You got to kind of put that to the side, okay? You can't get all wrapped up in that the person making the records request is your best friend or your worst enemy. You basically have to treat these requests all the same, all consistently, and respond to them timely, okay? Now, there's certain records that are not accessible. Those protected by the attorney-client privilege or the work product privilege, and we'll get to that in a second. The work product relates to litigation or adversarial proceedings. Information that you obtained in connection with the approval of the lease, sale, or other transfer of a unit. So the release or sale application, the screening information, if you do a background checks, all that kind of stuff, anything that you obtain in the course of a screening process or approval process, that's not accessible to the owners, to the other owners. The personnel records of your employees or the management company employees are not accessible. And that can be disciplinary records, payroll, health, and insurance records. However, personal records do not include, let's say, written management employment contracts or management company contracts, okay? And also do not include budgetary or financial records that indicate the compensation paid to an employee. So if the compensation is listed in your budget, the budget is otherwise available, then that's not a personnel record that's privileged. The medical records of owners are privileged. And bear in mind, this includes any letters or documentation that you get from owners or residents in support of their request for assistance animals, okay? Support animals in particular usually is what you get those letters from, or the documents. Those are medical records, okay? So no medical records can be disclosed to other owners. Electronic security measures that are used by the association to safeguard data, including passwords, that's privileged. Software and operating system used by the association, which allow the manipulation of data, even if the owner owns a copy of the same software, okay, that doesn't trump the privileged nature of the software. Additionally, the affirmative acknowledgments under 718.121, I mentioned before, they're not accessible. Number 8, very important, Social Security numbers, driver license numbers, credit card numbers, email addresses, telephone numbers, fax numbers, emergency contact information, and addresses of an owner other than as provided to fulfill the association's notice requirements, and other personal identifying information of any person. Those are all privileged, excluding or not including the individual's name, unit designation, unit number, mailing address, property address, and any address, email address, or facsimile number provided to the association to fulfill the association's notice requirements. As I mentioned before, email addresses are privileged, okay? Unless someone says in writing that that is the address to use for their notices from the association. However, the association can print and distribute to the owners a directory containing the name, unit address, and all telephone numbers of each owner. However, an owner may exclude their telephone number or numbers from the directory by written request to the association. So if you're going to do a directory, give the owner sufficient time and a sufficient deadline to opt out or exclude their telephone number or numbers from being included in the directory. Now, the association is not liable for the inadvertent disclosure of the privileged information if the information is included in an official record of the association and is voluntarily provided by an owner and not requested by the association. As I mentioned before, an owner can consent in writing to disclosure of other contact information otherwise not accessible. So email addresses, other addresses that typically are not accessible. If they've agreed to it, then they are. The association must ensure that the records not accessible to the owners are not posted on the website or the app. If protected information or inaccessible information is included in documents that are required to be posted, then you must redact them. I mentioned that before. Inadvertent disclosure. The association or its agent is not liable for disclosing protected or inaccessible information unless that was made with a knowing or intentional disregard of the protected or restricted nature of that information. Finally, the association is not responsible for the use or misuse of the information provided to an association member or their authorized representative in compliance with the Act unless the association had an affirmative duty not to disclose that information under the Condominium Act. We mentioned attorney-client privilege. What is that? Well, basically, anything that the attorney sends to the association, to the board, or the management company, or that they send to the attorney. All those communications, whether it's email, hard copy, whatever, those communications are privileged. Also, work product privilege. So that's any record that's prepared by an attorney, by the associate's attorney, or prepared at the attorney's express direction, which reflects a mental impression, conclusion, litigation strategy, or legal theory of the attorney or the association, and which was prepared exclusively for civil or criminal litigation or for adversarial administrative proceedings, or in anticipation of those proceedings until the conclusion. So, for example, if the association is going to sue someone or something or some company, and they've hired an expert to prepare reports or opinions for that matter, that was prepared in anticipation of an adversarial proceeding. So that comes under the work product privilege. Even though the lawyer did not prepare that opinion or that report, it was prepared in anticipation of an adversarial proceeding. So that's privileged. The communication of the correspondence from the attorney, that's privileged unless the board votes to waive the privilege. And only the board can waive that privilege. The attorney cannot waive the attorney-client privilege. So what if you mess up and you don't timely provide access to the records within 10 business days? That creates a rebuttable presumption that you willfully failed to comply. So an owner who is denied access or prevented or is not provided access to the records within 10 business days of the receipt of their request, they're entitled to actual damages if there are any. If no actual damages, then minimum damages. That minimum damage is $50 per day, per calendar day, not working day, up to 10 days, so $500. That calculation begins on the 11th working or business day after receipt of the request for the records or to access to the records. The failure to permit inspection entitles any person, if someone has to actually sue the association, if they prevail in an enforcement action to recover those records, then they're entitled to recover their attorney's fees from the person in control of the records who, directly or indirectly, knowingly denied access to the records. A director or a manager who knowingly, willfully, and repeatedly, which is 2 or more times in a 12-month period, fails to provide access to the records, commits a second-degree misdemeanor and has to be removed from office. We mentioned that earlier. The refusal to allow inspection or copying of an official record that is accessible to owners within the time periods required by law in furtherance of any crime is punishable as tampering with physical evidence or as an obstruction of justice. Any person who knowingly or intentionally defaces or destroys accounting records that are required to be maintained during the period for which the accounting records are required to be maintained, or who knowingly or intentionally fails to create or maintain the accounting records that are required to be created or maintained, with the intent of causing harm to the association or one or more of its members, he or she commits a first-degree misdemeanor and is personally subject to a civil penalty and also must be removed from office as director or officer. Any person who willfully and knowingly refuses to release or otherwise produce records with the intent to avoid or escape detection, arrest, trial, or punishment for the commission of a crime, or to assist another person with such avoidance or escape, they also commit, or she commits, a third-degree felony and must be removed from office. So again, these are all terrible things, but hopefully will never occur to anyone who's on this Zoom. The destruction of an official record in furtherance of any crime is punishable as tampering with physical evidence or as obstruction of justice. How about the return of the records? An outgoing board or committee member must relinquish all official records and property of the association in his or her possession or under their control, and must relinquish them and provide them to the incoming board within 5 days after the election or after they're no longer on the board. An outgoing board or committee member who willfully and knowingly fails to relinquish the association's official records is subject to a civil penalty imposed by the state, imposed by the division. That is my portion.
Well,
Today's marathon.
marathon is what, about halfway done now. Apologies, we lost about 8 or 9 minutes when I had to reboot. Apologize to everybody for that. Peter, well done. I know Andy is here. We'll introduce Andy in just a second. I just want to remind everybody that if you have not already hit the chat button, it's at the bottom of your interface. If you don't see it, just hover over the bottom. After you hover over the bottom, choices will appear. Press the chat button one time, simply so it appears. It will say your chat is disabled. That just means you cannot communicate this way, but we can send stuff your way. That's where we're going to place the evaluation link a little bit later. And because of my technical issue here, we're going to bid farewell to Peter. Peter, any parting words before you head out? I know we didn't get to any of the questions, but we
I want
have
to
a lot of
thank
material.
everyone. I want to thank everyone. Now we have our cleanup hitter and anchor man coming on, the big gun. So
Ron Burgundy, Anchorman. No, I'm sorry.
well, I don't know about that, but Andy is tremendous and excellent, and everyone is going, I'm putting pressure on him now, and everyone's going to enjoy his presentation greatly, and I thank you for your time. Thank you.
Thank you, Peter. Be well.
Okay, you too.
See you. And now we have from our Pompano location, we're going to travel about 45 minutes south. Andrew Black, another board certified specialist in condo and plan development law out of our Pompano Beach location, is going to carry us the rest of the way for topics 3 and 4. And remember, if you do need to take a bio break or go get a quick drink, just leave it running, do your thing, come on back. And my technical glitch is the perfect example of what I was explaining earlier. If you get booted off, just make the effort to come back in as quickly as possible. We can tell from the official Zoom timestamps. But again, if you're gone for 30 minutes and you come back, that's another story. But we can see when you make the effort to come back really quickly. Andrew, I'm going to turn it over to you, sir. Good to see you. How are you?
Awesome, Jeff. I'm doing great. And I know we're sort of at the halftime of a 4-hour day. So I certainly applaud each and every one of you. You could be anywhere in the world right now, but you chose to spend some time with us, and we greatly appreciate that. Let me get my outline up.
Okay. And while Andrew's doing that, we also once again want to thank ACAM for collaborating with us today. So Eric will hop back on a little bit later after Andrew gets through with his couple of sections here.
You got it.
And not sure where you are, but we're still stuck on the Peter business card page. That's what we see.
Oh, all right. Let me. Interesting. I'm scrolling. Are you seeing mine?
Now it's showing page 99, it looks like.
Yeah, I'm going down to topic 3. We're almost there on page 88.
Oh, gotcha. Back.
You got it now?
Transfer fees.
Yeah.
We're good.
Stop. Okay. All right. Well, again, I want to thank you all. I know it's a long day and your heads are probably spinning somewhat. I'm going to try to bring up all of your guys' mood and start with some financial things. And the first topic or the first slide is dealing with transfer fees. Okay. And transfer fees deals with the amount of money you as a condominium association can charge an applicant who wants to buy or rent. Hopefully you all know, but the authority to charge the transfer fee, your governing documents must support it. So either your deck, articles, or bylaws must have the triggering language to allow that transfer fee. Per statute, this is in chapter 718, it's $150 per applicant maximum transfer fee. Other than husband or wife or parent, dependent child, they're considered one applicant. But per statute, 150 is the max. So a common practical question we get is, well, our background investigative company, someone's applying from outside of the United States, for example, and they're charging us more. They're charging us $200. What can we do? And I say, don't shoot the messenger. That extra $50, you all have to just accept that as an operating expense, because the most you can charge the applicant is that 150 max. Okay. Also, very important for someone that wants to rent, another common fee is a security deposit. Similar to the transfer fee, your governing documents must have that triggering language that authorizes you all as an association to collect that security deposit. Okay. The maximum per statute is 1 month's rent. So you cannot charge a security deposit in excess of that 1 month's rent. Besides the transfer fee and the security deposit, condominiums per statute are not authorized to charge other types of non-refundable fees. And by the way, I should just mention quickly, the security deposit is refundable. It's only used for damages to the condominium property that the tenant may cause while the tenant is residing there. If there's no damage, the tenant doesn't break anything, at the end of that tenant's lease, per statute, you have to return that security deposit. If there is damage and you want to make a claim on that security deposit, there's actually a statutory form letter that must be sent. So if you're obviously on your board, get with your management team. Certainly, if you have any legal questions, get with your attorney to make sure you're following the correct legal process to make a claim on a security deposit. What I was about to go into is that besides the transfer fee, besides that security deposit, associations are not authorized under Florida law to charge all sorts of other non-refundable fees. We've seen all sorts of things. We've seen non-refundable, a fee when someone wants to, have a pet, or, rent the service elevator to move in their furniture, and boards will try to charge non-refundable fees for those types of things. In our view, those fees would be subject to a successful challenge if one is made. So be very cautious and aware of what types of non-refundable fees you're charging at the application process. There was actually in Miami-Dade County, by now it's been several years ago, but there's actually a class action lawsuit filed regarding various non-refundable fees that many associations and even management companies were charging. So again, be very aware of your authority. Again, your documents can authorize a transfer fee, 150 max, or a security deposit not to exceed 1 month's rent. The next several slides, and my goal here today is, I don't want to read line by line, right? I want to focus on some of the primary issues that we see as the attorney for our condominium clients. So we have several slides going over what's called an estoppel certificate. I think it's very important for you all as board members to be aware of this, but I'm not going to go over line by line. But the main takeaway is, what is an estoppel certificate? You've probably heard that phrase. What an estoppel certificate is when a condo unit is being sold. Usually the title company will request an estoppel certificate primarily to know what monies are unpaid, what's still owed on the unit, so the new buyer is fully aware of what the assessments are and other relevant information. Usually the estoppel certificate is handled at the property management level, but certainly we have lots of self-managed clients out there. So you need to be made aware of this estoppel certificate process. If you get a request, you have 10 working days to make sure that that estoppel certificate is accurately completed and returned to the requesting party. The content, what's in the estoppel certificate, it's actually a statutory form. So it's not rocket science. You don't need to think of what should be on there. There's a form right in Chapter 718. And it's really common sense stuff that if a new owner, if you were a new owner, you would want to know, such as, do you have any assigned parking spaces? Any assigned storage spaces? Obviously, the assessment information. Are they paid monthly? Are they paid quarterly? Are there any special assessments out there? All of that assessment information is crucial. And you want to make sure, of course, that it's accurate. Because if you don't include a pending assessment and the new buyer buys in, there's an argument that that new buyer could claim that, you know, they weren't aware of that. It wasn't on the estoppel certificate. And the estoppel certificate is the vehicle for that new owner to know what is owed. Again, this slide, just the last two actually go through what type of content needs to be on the estoppel certificate. Obviously, this is positive news, certainly if you're in the management company world or even if you're self-managed, but you can charge fees for preparation of an estoppel certificate. The fees are listed right here. Oftentimes a title company, and I love people who buy and sell real estate. I have realtors in my family, but certainly they always want the deal to close a day ago, right? There's always an urgency there. So the statute does allow a requesting party to order a rush estoppel to get that on an expedited basis. And if they do request that, you could charge more fees. And this schedule of fees is right there. Okay. The fees that were on 2 slides ago, they will be adjusted every 5 years based on the consumer price index. So just be aware of that as far as what amounts you all are charging. Estoppel certificates are generally valid for a 30-day time frame. If you're sending it via the old school way, via mail, it's a 35-day time frame. Okay, so that's the estoppel certificate portion of that. And again, since the state of Florida requires us as part of our board member certification course to touch on these financial matters, I think it is good that you're aware of that estoppel certificate process. There are other times, and certainly if you're on a board and you deal with a lot of the day-to-day unit sales, you might get questions from, for instance, a bank that is issuing the mortgage to the buyer to buy the condominium unit. And oftentimes that lender, that bank, they want to know all sorts of things about the condominium. They're doing their due diligence on their end to make sure that when they are loaning money to this buyer to buy this unit in this condominium, they want to know the health and the status of what the condominium is all about. So oftentimes you'll get what's commonly referred to as a lender questionnaire, where I've seen very lengthy ones. The good news is under the statute is you don't need to provide that information, certainly at all. Most condos certainly do. I mean, you don't want to feel the wrath of the owners who are unable to, get a mortgage from a bank because you won't cooperate, but you can charge a fee for preparing the answers to those lenders questionnaires. It's $150 maximum fee. But certainly be aware of that. If you're dealing with lender questionnaires, you can certainly ask for that, those funds, and you certainly should. Very important. The last italicized language on this slide is any agent of the association, whether you're a board member doing these lender questionnaires, certainly be in touch with your management team. But that italicized language at the end, that the responses herein are made in good faith, that line should be included on any response that you give to a lender questionnaire. Okay. There's a couple other purchase and sale forms that often arise, and I think it's crucial for you as board members to be aware of them. One of them is what's called the condo question and answer sheet. It's oftentimes labeled a FAQ, right? Frequently asked questions. This is a document under Chapter 718 of the Florida statutes that an association must have. It's part of the official records that owners get to see. And certainly the selling owner must actually give a copy of this to the buyer. It's a form that the state of Florida, via the DBPR, they have what the questions and answers are, and it's your job as an association, based on the language of your unique governing documents, to provide the answers. The questions are pretty much: what type of use restrictions are there? What type of rental restrictions are there? What's the assessment amount? How often do you pay? Is it monthly? Is it quarterly? Is there any litigation that the association is involved with? It's a one-page frequently asked question sheet. If you're on your board right now and you're thinking, I have no clue whether we have this frequently asked question sheet, definitely get with your management team. If you're self-managed and you don't have any idea what I'm talking about, 100% you should be getting with your association's attorney. They could likely, he or she could assist you with making sure that you get that frequently asked question sheet properly completed and kept. This slide is dealing with, again, we're still talking about the process when a condo unit is sold and what type of documentation is involved. These are items that the unit owner himself or herself, this isn't an association obligation, this is the selling owner, he or she has the obligation to make sure that they provide certain documents to the buyer. And it's the deck, the articles, the bylaws, the rules, and that frequently asked question sheet. So you want to be aware of that. As well, the state of Florida has a condo governance form. Okay, this is a statutory form, but this is also something that should be provided by a selling owner to someone that wants to buy. All right, so those are some of the important documentation regarding the unit sale process. We talked about transfer fees. We talked about estoppel certificates. We talked about lender questionnaires. We talked about the frequently asked question sheet. So that's all at the process of when, again, a condo unit is being sold. We're going to shift gears somewhat, still dealing with some financial matters, But this is now dealing with more day-to-day operational aspects. Dealing with what if an owner breaks a rule, okay? What are some of the enforcement rights, specifically the ability to suspend someone's right to use the common areas like the gym, the pool, the clubhouse. Also, can we suspend anyone's ability to vote for certain things, as well as the ability to levy a monetary fine? Okay, so there's several slides on this. Again, I'm not going to be reading line by line, but the main takeaway is, if you're thinking about as a board, what are some enforcement rights that we can utilize if an owner or a tenant is breaking our rules? The Florida statutes, it's right in chapter 718.303. They allow an association to levy a monetary fine or suspend the use rights of an owner. Now, it is not solely a board vote. In order to fine or suspend use rights for a rule infraction, the association must have an independent, impartial committee of at least 3 other unit owners. So let's stop right there. We have lots of clients. They have a hard time finding enough people who even want to volunteer and serve on the board, right? We always joke that being a volunteer board member in a South Florida condominium might be the most underappreciated and hardest volunteer role that's out there, right? So lots of places have a hard time even finding people who want to serve on the board. So it may be practically hard to find 3 willing owners who want to step up and volunteer to serve on this impartial committee. It's often called a grievance committee, a fining committee, whatever you want to call it. It's that impartial body of 3 owners that must be established. So if you don't have that independent committee established, you do not have the authority under the Florida statutes to levy a monetary fine or to suspend common area use rights for someone that breaks a rule. So the step 1 is make sure the board, it's a majority of the board vote, the board can create that independent committee. Once the committee is established, and again, this goes hopefully without saying, but that committee can't be on the board, can't be officers, can't be employees, or related to any officer, director, or employee. Per statute, the maximum fine is right here on your slide, $100 per violation, not to exceed $1,000 in the aggregate for a continuing infraction. So let's say your governing documents have clear language prohibiting commercial trucks. An owner has a commercial truck, you've uniformly enforced it. You can only fine $100 a day up to $1,000, right? So $100 a day for 10 days. If it's there 10 days, that $1,000 is the maximum fine amount. Importantly, a fine per statute cannot be the source of a lien. Okay, so it's not part of that assessable sum that you can levy against an owner subject to the lien and foreclosure process. So you may be asking, so how do we get a fine then? Well, for one thing, it stays on the account ledger of that owner. So if they ever go to sell, it's reflected. And when you issue that estoppel certificate, that fine should be showed there, and you could hopefully get it paid at closing. Okay. But a fine, again, can't be the source of a lien. So that's dealing with the fining process for an owner who does not, comply with your governing restrictions. Also, I just want to point out, under the statute, you can suspend the common element use rights for an owner failing to pay any monetary obligation for more than 90 days. So this is when you're suspending common element use rights, like using the gym, the clubhouse, the pool. But this is when you want to do it just because the owner is 90 days past due. The statute expressly authorizes that, with the understanding that you don't need an independent committee process for that. Okay, so that's a very important thing. Obviously, from a practical standpoint, suspension of common element use rights only really works, in my view, if you have some sort of electronic fob access where you can just shut that off, right? So they can't get into the gym or the pool via that fob. If you don't have electronic access, I don't really know of too many communities that have the resources or the manpower to sort of watch over the gym or the pool. An important caveat about suspension of common area use rights is you can never suspend the ability of someone to park their vehicle or to access their actual unit. All right. So, or any utility services. Okay. So make sure you're aware of that. Obviously, someone has the ability to have access to his or her home and to use utility services. Okay. Let's talk about the ability to share here. I think my outline went off. Apologize about that. Hold your eyes if you get a little bit seasick for a minute. Let me just scroll back down.
And while Andrew's doing that, just a quick reminder for those of you who might not have heard this earlier: activate your chat area, hit the button one time simply so it appears. Ignore the fact that it says chat is disabled. We can still send stuff your way, and that's where the evaluation link will be placed later. Back to you, Andy.
Thank you. And that was a perfect little break. And also, just as Jeff said, I'm sure it's been said multiple times, but we really do read every feedback we get. And I definitely truly appreciate any constructive comments that you all have. Back to our slide. Here, we're talking about the ability to suspend voting rights now. Okay. Again, the statute allows an association to suspend voting rights if an owner is more than 90 days past due. However, there's several other hurdles that must be met, which in my mind makes it a pretty large, undertaking to make sure the board does it properly. But the main one is that it's got to be more than 90 days past due. The past due amount has to be more than $1,000, and proof of that obligation must be sent to the owner 30 days prior. Okay. Also, if you're looking to suspend voting rights for an election, the owner needs to be informed that their voting rights have been suspended 90 days prior to that election. So in my mind, you need to make sure you're suspending voting rights properly. I want to spend a moment on suspension of common element use rights or voting rights for an owner that's more than 90 days past due. I mentioned that you don't need that independent committee established. However, the board still needs to have a duly noticed board meeting, notice and an agenda posted 48 hours prior, where the board approves suspending common element use rights or voting rights. Thereafter, you need to then send written notice to that owner that says, at the board meeting held on whatever date, the board voted to suspend your ability to use the following common element areas or your ability to vote. And obviously, any suspension for an owner that's more than 90 days past due, that suspension ends once their account is brought current. All right. Also, regarding finding, just before we go on to the next slide, that $100 per violation up to $1,000 in the aggregate, that's for each infraction. So if you have an owner that really doesn't like the rules at all, he has a commercial truck that's not supposed to be there, and he has a 100-pound dog that's not supposed to be there, you can treat those as two separate infractions. And in theory, there could be $2,000 of fine imposed against that owner, $100 a day up to 10 days for the truck, $100 a day up to $1,000 for that pet that's not supposed to be there. Also, regarding fining for a rule infraction, I've said multiple times regarding the independent committee that must be established. You also have to make sure you're sending notice, a 14-day notice to the owner that there's been this fine approved against him for whatever rule infraction. And that owner has the ability to attend a hearing in front of that independent committee. And it's the job of that independent committee to either confirm or reject that fine. Okay. And if that fine is approved, it's payable 5 days after notice is sent to the owner that committee has approved it. All right. On to some other financial matters. Obviously, my wonderful colleagues, Peter and Ben, during the first part, I'm sure spent a lot of time on the structural integrity reserves and milestone inspections, and I'm not going to go over any of that again here. This is just sort of the general nuts and bolts of the annual budget and reserve process. Obviously, a budget must be adopted every year. That's why it's an annual one. It's a good faith estimate of what the estimated operating cost will be. So you obviously, as a board, take a look of what you did last year and make any reasonable good faith adjustments for the upcoming year. The annual budget itself obviously needs to outline what the assessment obligation of each unit type is, as well as the what the reserve contributions are as well, and I'll get to that in a second. There's really two sides. Okay, one side of the annual budget is obviously the operating expenses, and again, it's a good faith of what they will be in the upcoming year. These things can include, the list is right here, administration, management, maintenance, insurance, all of those fun things. Those are the operating expenses. If you have an issue with perhaps owners not paying their assessments on time, you might want to include a bad debt line item as well. And whoever assists you in preparing that annual budget, certainly if you have a licensed property manager or a property management team, they assist with that process. The process to adopt the annual budget each year, and you all hopefully know this, but the budget is adopted by the board. Okay, so the board meeting notice, along with a copy of the proposed annual budget, must be mailed to every owner, and the notice is posted 14 days prior. Okay, so not 13 days prior, not 12 days prior, right? At least 14 days prior. Okay, and important item is this last line of this slide. If for some reason there was a good faith change from the time period within those 14 days when the proposed annual budget was sent out, the board can make changes at the board meeting as far as what items or the amounts that are included. Okay. Now, so that's talked about the operating expenses, talked about the 14-day notice of the board meeting where the board adopts the annual budget. The other side of the budget is obviously reserves. And certainly if you've been in the condo world at all for the last couple of years, you've heard nothing but reserves and structural integrity, reserves. So again, I'm not going to go through it in that level of detail here, but it's important to know what the reserve terms mean, right? So you have capital expenditures, you have deferred maintenance, and then we give some examples for you. And the easiest way to think about what reserves are, it's really rainy day funds, right? You're putting money away each year. So at the end of the useful life of that reserve item, you have a pile of reserve money that can be used to address that reserve item without having to special assess the owners. Obviously, you get a reserve study, and that qualified third party takes a look at what your reserve items are, and they reflect on that reserve study the remaining useful life of that reserve item. So the roof, for an easy example, there's 10 years left. Your roof's going to need to be replaced in 10 years. It's going to cost approximately, I'm just using round numbers, attorneys hate math, right? But it's going to cost $100,000 in 10 years to replace that roof. Therefore, to fund that roof reserve, you put away $10,000 each year. Owners are contributing that reserve funds each year. Okay. I want to point out something, and I'm sure Ben and Peter both touch base on it, but we're obviously teaching this board certification course. It's May 29th of 2025. We're teaching it as the law exists as of today. There is a bill that it's anticipated the governor will sign. It's passed both chambers of the Florida legislature. It's House Bill 913. Okay. And you'll be hearing lots more from our firm about House Bill 913, certainly once it gets signed into law, which again, we expect it will. And if it does, it'll be effective July 1st of 2025. So we're giving our presentation today, obviously, on what the law is today. But I wanted to just point out on certain slides, if you see something that says if HB, which is if House Bill 913 is signed into law, and then I'll add something there. I encourage all of you, our firm will be giving legal update courses. You should sign up for our email blast. We send out lots of information and articles about these legislative changes. It keeps us on our toes, obviously. I believe House Bill 913 is about 190 pages long. There's a lot of fluff in there, but again, the legislature changes things pretty significantly. And it's certainly our job as counsel to make sure our clients are being informed, and even the general non-clients as well. We want to encourage that. So a little tangent right now, just to make sure you all are aware. Again, it's House Bill 913. Certainly check our website for upcoming courses and seminars and Zooms and articles will publish about it. Having said all of that, under 718, they list certain items that the annual budget must include for just general reserves, okay? Such things as roof, building, pavement, and any other item that has a deferred maintenance expense or replacement cost that exceeds $10,000. as you will note, if House Bill 913 is approved, this will be increased to $25,000. This slide here just talks about the formula, how you compute reserves. And again, this is going to be based on the reserve study that your association obtains that lists your every reserve item. It'll show what the approximate remaining useful life is, what the estimated replacement cost will be at the end of that useful life, and what money you would then need to contribute each year. Think of my roof example. There's 10 years left. It's going to cost $100,000 to replace that. Now, the ability to waive or reduce, some people call it partially fund, but the ability to do anything other than fully fund your reserves each year, it used to be before the structural integrity stuff, it used to be the board had the ability to offer owners the option to vote to either completely waive reserve funding for that year or just to partially fund reserve funding for that year. That has now changed. You all are aware of that. And for any structural reserve item, the way the law is right now, there is no ability to waive or partially fund structural reserves. You got to fully fund it. I'm just making a brief note, the first line here, there is language in that new House Bill 913 that, subject to owner approval, it would allow the possibility for an association to temporarily pause the funding of structural reserves for up to 2 years. Now, if you get the owner vote to pause it, at the end of the pause, you need to get a whole new structural integrity reserve study done. So I'm not sure if even the concept of pausing would really be a true advantage for most associations that have been fully aware of the structural integrity reserve requirements, have planned appropriately. And for lots of boards I've talked to, that ship has already sailed. They've already done the financial, the planning for all of this, and they're not really looking to pause for 2 years just to have to get a new structural integrity reserve study done. But I just wanted to point that out to you. Now, for non-structural reserves, the law still does allow the board, if they so choose, to offer the ability for owners to waive or partially fund the non-structural reserve items. You need an owner vote. It's a majority of all owners, okay? So you do have that ability to, right now, you have the ability to waive or partially fund non-structural reserves. Also, reserve items, you all have probably heard this, they're restricted for that reserve purpose. So if you use what's often called straight line reserve funding, where you have individual reserve accounts, your roof reserve, those funds in that roof can only be used for the roof, okay? They're restricted. And under the law, you're only allowed to use designated reserve funds for an alternative use if you get the approval of the owners, okay? And an important caveat, that's only for non-structural reserves. The law has made this very convoluted over the last few years. But the main takeaway is you can only use reserve funds for something else if it's a non-structural reserve item. Also, you all have heard about pooled reserves, okay? You can pool reserve accounts, all right? Pooling is where you group all of the individual line items and you put it in one single pool where you can use those funds for any item in that pool. You can pool non-structural reserve accounts into a non-structural pool. And you can also pool structural reserve items, but it must be a structural pool. You can't co-mingle a non-structural pooled account with a structural pooled reserve account. And I want to point out here that if House Bill 913 is approved, there is language that just officially confirms the ability to pool both structural reserve items into a structural pool and to pool non-structural items. If you are going to be presenting the issue to the owners, whether to waive or partially fund non-structural reserves, okay, or to use non-structural reserves for an alternative use, owners can vote. It'll be a vote at an owners meeting, obviously, and owners who aren't physically there can vote via limited proxy. But the main takeaway from this slide is there needs to be bold and all caps language. It's right here on your slide on that limited proxy form. It's basically disclosure language to the owner saying, look, you're voting on either waiving reserves or maybe using reserves for an alternative use. If that does get approved, it may result in a special assessment. So absolutely, if you're on your board and you're thinking about presenting to the owners a vote of this type, certainly we recommend getting with your association counsel, make sure he or she takes a look at whatever limited proxy you all have to make sure it's got this required disclosure language here. All right, last couple slides on topic 3, and then we're left with the last topic, topic 4. Again, dealing with financial matters, annual financial reports. Obviously, I shouldn't say obviously, I should say hopefully, you all are aware of your obligation to have a financial report prepared each year, okay? And you must provide a copy of the financial report to each owner, or at least notice that one's available to them at no charge. And you have a time frame from the end of your year, whether it's you're on a calendar year or some other year, you have between 21 and 120 days to provide that financial report. I make a brief note that if House Bill 913 is signed into law, that 120 will be increased to 180 days. The main thing is owners get free of charge a copy, or at least notice that the annual financial report is available to them. Just want to touch base on the level of financial reporting. It's based on what your annual revenues are, okay? So very simply, the more revenues you have, the higher level of financial reporting you're required to do per statute. So if you have between $150,000 and $300,000, you're just required to do compiled financial statements. If you're between $300,000 and $500,000, you have reviewed financial statements. If you're $500,000 or more, you have to do an audit. And I also mentioned some governing documents I've seen, especially some older ones, in the bylaws. Usually there could be language that says you must do an audit each year, regardless of what your annual revenues are. So if your bylaws say you need an audit each year, technically you got to get an audit each year. We have some clients that have presented an amendment to that language for the owners to vote on, to simply say the association will adhere to its financial reporting requirements as required under Chapter 718 of the Florida statute. So over $500,000 per statute, you need an audit. And if you're less than $150,000, it's just a simple report of cash receipts and expenditures. Now, let's say you have annual revenues of $400,000, okay? And your bylaws are silent regarding and having to do an audit. So you're at $400,000 per statute. You must do reviewed financial statements. Sometimes we're asked, a board says, look, we know we only have to do reviewed financial statements, but we haven't done an audit in a long time. Perhaps we've never done one. And we think it's time that we do it at least this year. And does the board have the authority to increase the level of annual financial reporting? The answer is yes, the board certainly does. They don't need any owner vote to increase the level of financial reporting. However, and you can probably see where I'm headed with this, the board cannot lower the level of financial reporting via solely board vote. You would need to seek and obtain the approval of the owners to reduce or lower your level of financial reporting. All right. So that's topic 3. I'll take a quick peek. I'm trying to keep us on schedule here, and it's 2 o'clock, so we've got about an hour for the last topic. Got a couple questions going back on the finding committee stuff. Yes, the finding committee must be a unit owner. I got a question about that. We got a question on just the general reserve requirements. Again, I'm not talking about CEUs, right? Because the structural integrity reserve study is only required for condos 3 stories or taller. But there's also non-structural reserve requirements in Chapter 718, and that applies to all condos, even under 3 stories. So that addresses that question. All right. We also got a question about, and this can happen where a board properly suspended the ability of an owner to use the common areas, and they just ignore you, right? Again, practically it's tough unless you have some sort of electronic fob. Other things the board can do, ultimately you can get with your attorney, and perhaps if it's really a flagrant infraction, think about, filing formal legal action and perhaps filing a lawsuit to seek injunctive relief, which is just a fancy word for getting a court order forcing someone to not take certain action. All right. Those are some great questions. And again, I genuinely appreciate you all here as I take a sip of water. All right. Last topic. We're in the home stretch. This is when you kind of stretch out here. Just stay with me a bit longer. I think there's some pretty interesting stuff coming up. This is dealing with a lot of, again, operational, sort of non-financial operational aspects that board members of condominiums should be fully aware of. We're talking about how things get approved, whether it's approved by the owners at a members meeting, members just means the owners, or if things get approved by the board at a board meeting. For members meetings and meetings of the board, there's specific notice requirements. And sometimes I get clients that sort of conflate or confuse the two, and they don't even know what type of meeting it is. And an easy, hopefully obvious rule of thumb is the question is, who's voting? If the owners are voting at the meeting, it's a meeting of the owners. If the board is voting, it's a meeting of the board. Sometimes you can have an owners meeting immediately before a board meeting. That can happen. The 2 notices can even be on the same piece of paper that's sent out. But if the owners are voting, it's an owners meeting with its own quorum of owners requirements. And if the board's voting, it's a meeting of the board where it's just a quorum of the board is there. So let's talk about owners meeting again. The main owners meeting is the annual meeting. Okay. Sometimes this is the only owners meeting a condominium may have. The annual meeting is where the election happens. Okay. And I believe my colleagues, either Ben or Peter, went through the election process probably in really great detail. So I'm not going to go over that now, but I just want to make sure we're aware the annual meeting, that's where the election happens. Also, there could be special members meetings. Again, member just means owner. So I use those terms interchangeably. There could be a special owners meeting. That quite simply is just when the owners are voting on something outside of the annual meeting. Okay. Notice of a special owners meeting. You check to see what your governing documents say, because you want to follow that. If your governing documents are silent, that notice of the special owners meeting is mailed and posted to all owners 14 days prior. Okay, 14 days prior. Obviously, it's furnished to the mailing address. You could also email the notice to any owner who's consented in writing to receive notices via email. So if you want to save a stamp and not be required to mail it, maybe one thing to do is get with your association's attorney, get an email consent form drafted and sent out to all owners to say, hey, sign this form, give us your email address if you authorize us just to email you the whatever the association wants to send out. Okay. Obviously, the notice must have an agenda item. I talked about emailing the notice and the agenda. Again, the key thing is you need the owner's consent in writing. In my opinion, it's not good enough that you just happen to have the email of an owner and therefore you only email the notice to them. You don't mail it. To me, that's not valid. You need to make sure you have their signed consent that says, here's my email address. You, association, are authorized to use this email address to send me official association things. Okay. All right. Obviously, those communities that are required to have a website, right now, if you have 150 or more, you have to have a website and you have to post whatever notice packages you send. Keep in mind that as of January 1, 2026, any condo that has 25 or more units will need to have a website. So be aware of that for any board members out there that are 25 or more units. But the main takeaway from this slide is if you have to have a website, you must post whatever notices are sent must be posted and available on that website as well. All right, we're still talking about meetings of the owners. In order for the meeting to even occur, you need to establish quorum. Quorum is just a fancy word, right? It means the minimum number of owners that are present either in person or by proxy, or if you've done electronic voting and there's a process to follow to implement electronic voting, but an owner who votes via electronic vote, they can count for quorum purposes as well. But a quorum is just the minimum number of owners you need to be in attendance to even have the owners meeting. If you don't have quorum, the business of the meeting cannot be conducted. You check your bylaws to see what the quorum requirement is. If your bylaws are silent, it's a majority, which is 50% plus one. Okay, that's what you need 50% plus one of the owners in attendance to have quorum. Okay, so just be aware of that. At meetings of the owners, just like board meetings, owners can obviously have the right to speak on any agenda items. They have the right to even record a meeting. Okay. Sometimes board members say, well, I didn't consent to being recorded, and I have to be the bearer of bad news and say the statute doesn't require consent for an owner to record either, quite frankly, either a meeting of the owners or a meeting of the board. Owners have the right to record both. Obviously, we have in the slide some, common sense rules. You know, an owner can't be moving around the room, shoving a camera in somebody's face. But it would be improper if you're on the board to say you're prohibited from recording. All right. Now, again, we're talking about meetings of the owners. Okay. I would say 99.9% of the time, a special meeting of the owners. Let's talk about some common things that owners may vote on. Let's say you want to amend your governing documents and you need an owner vote. That vote could be done at a special meeting of the owners. Let's say you're voting to partially fund non-structural reserves. That meeting could be done at a special meeting of the owners. Let's say your governing documents require an owner vote for a material alteration to the common elements. That vote could be done at a special meeting of the owners. And the way that owner vote is cast is via what's called a limited proxy if the owner chooses not to physically show up. Okay. If the owner chooses to physically show up, they can vote via a ballot at that owner's meeting. But if they don't show up, they can vote via limited proxy, which is where the owner, I'm John Doe, I own unit 101. I can vote exactly how I want to vote on that limited proxy form. So whether I want to approve the material alteration, I vote yes. I sign it, I date it, then I can submit my limited proxy, or my proxy holder can drop it off for me, but I'm still voting the way I want to vote. And that is, that's how votes are done at a special owners meeting if an owner doesn't physically show up, okay? Also, limited proxies, they're valid for 90 days from the date of whenever the owner's meeting is held. So you have a 90-day time frame. Let's say you go to the meeting of the owners, you're a few votes short, you have the ability to not adjourn the meeting, but you could recess and reconvene the special owners meeting to a future date, make sure it's within that 90-day time frame, and you're able to collect additional limited proxies. Limited proxies are revocable by the owner. So I'm, again, John Smith. I don't show up to the meeting. I can vote via limited proxy. Let's say I turn it in a week prior to the meeting. I can change my mind and submit a later dated limited proxy. And it's the later dated or the most recent limited proxy that controls my vote. So that's the meetings of the owners. Again, that's where owners vote, and you need a quorum of the owners for the owners meeting to even be had. The other types of, and these are obviously a lot more common, are meetings of the board. That's where the board votes, okay? Before I get into the board meeting process, I think it's very important to highlight, and perhaps this was chatted about a bit earlier as well, but I think it's crucial to highlight, to me, the most important obligation that every member of the board has, and that is your fiduciary duty to the owners. That is just a fancy word. You're in a position of trust where every choice you make as a board member, the primary goal should be what's in the best interest of the entire community. It shouldn't be what will benefit me the most as a member of the board, okay? You're that fiduciary duty. Again, you're in a position of trust, okay? The way courts historically have viewed whether a board breached its fiduciary duty, and we've seen certainly lawsuits filed by owners where one of the claims is the board breached its fiduciary duty. What courts will analyze is, did the board act as an ordinarily prudent member of the board would have acted if presented with the same facts? Okay. Now, attorneys can argue what would an ordinarily prudent member of the board, what would he or she have done? But that that choice is all based on a reasonableness standard. And what does that mean? It means if you're on the board, you're consulting with your licensed professionals in evaluating what is in the best interest of the entire community. So if it's an insurance matter, you're consulting with your licensed insurance professionals. If it's a legal matter, obviously you're consulting with your attorney. If it's a property management matter, your licensed property manager. If it's a accounting financial issue, you have your licensed financial professionals as well. Your licensed engineers that you might hire to, dealing with common element repairs. That consultation process, receiving opinions, reports from your licensed professionals, that's what an ordinarily prudent member of the board, that's what he or she have done. Now, when you rely on that advice, that guidance from your licensed third parties, the board then uses what you all think is your business judgment. What is the best course of action? I can share with you, courts typically give pretty wide latitude to boards to use their reasonable business judgment. And courts historically have been very reluctant to substitute the judge's own judgment for that of the board. Okay, so unless the board really acted in bad faith or in an arbitrary manner, provided you're gathering advice from your licensed third parties, you're acting in a reasonable way, almost always you would have been seen as using your business judgment, and therefore there was not a breach of your fiduciary obligation. Okay, so I think it's important. That's sort of the prism that I want each of you to view your role as a board. You have that fiduciary duty. You're in that role of trust. Okay, so regarding powers of the board, this hopefully is not news to you all, but being on the board, every board member gets one vote on a board matter. No one gets a special vote, okay? Each board member gets one vote, and its majority of the board controls what that policy choice will be, okay? So just be aware of that, all right? Now, over the last several years, the laws have been changed to pretty much criminalize certain aspects of serving on a board. Hopefully, this is all common sense to you all. But now in Chapter 718 of the Florida statutes, which is the Condominium Act, they make it abundantly clear that board members cannot engage in any behavior that involves receiving a kickback, okay? And that word is defined right there. It's basically where a contractor in the, old sort of mob films, they hand you a bag full of cash to, approve their, job, right? You can't do anything like that. Also, this is important. There's a prohibition on using a debit card, okay? Not a credit card now, but using a debit card is strictly prohibited. So an association, its officers, directors, any debit card that may be in the name of the association is improper, shall not be used at all. There's no exceptions to that, okay? This is sort of an interesting quirk in the statute because usually in this country, you're innocent until you're proven guilty. In the terms of serving on a board, it's sort of the other way around, meaning a board member is removed from office if they're criminally charged with certain crimes. So there doesn't need to be a finding of guilt. It's just the mere fact that the state has charged a director with certain crimes, and that list is right there: forgery, theft, obstruction of justice. Those crimes, if in fact a director is charged, that board member is removed. That board member does not get to stay on the board until those charges get resolved. Okay. Now I want to spend a bit of time, because we get asked a lot about, how do you stay on the board, or more commonly, how do we get someone off of the board? And there's really only 6 ways. One of them is, we have the list right here, but one of them obviously is the board member resigns in writing. We certainly advise resignations to be in writing. There's even language to that effect in Chapter 617 of the Florida statutes, which is the Not-for-Profit Corporation Act, which includes condominiums. And the reason why resigning in writing is so important is you don't want to get into a fact pattern where someone says, I didn't say that, or I was just joking, or I didn't mean that. There could be a million sort of uncertainty that could arise from a verbal resignation. So make sure someone resigns, just get it in writing. So that's option 1. Someone's obviously off of the board if they resign. Option 2 is if the owners recall a board member from service. And the way that works under the statute is it's a majority of all owners. So 50% plus 1 can recall a member of the board without cause. There does not need to be a reason for it. Okay. It can be without cause. Almost always the recall process is done via a written recall agreement. There are certain procedural steps that have to be followed. My advice to all of my clients is if you get served with a recall agreement, that's the time you should get in touch with the association's attorney to just review what was served to see if it's valid or not. I also want to just pause here for a second. I'm sure this was chatted about earlier, but I want to make sure I'm being abundantly clear. Obviously, what I'm going over today is general information. Okay, this is my attorney spiel here, where nothing I'm saying today should be construed, right, as direct legal advice for your board or for your condominium. Okay, everything is fact specific. There could be a wide variety of things happening. So it wouldn't be appropriate for you as a board member to go back to your other board member and say, I met with an attorney, I got an attorney opinion, we can do X, Y, or Z, right? Obviously, that's not appropriate. If you have any legal questions regarding your community, you obviously need to consult with your current association counsel. All right, so I just want to kind of a random time to point that out, but it just came to me and I didn't want to forget to say that. So anyways, that's option 2, okay? A board member could be recalled by majority vote of all owners. The third way is if a board member is more than 90 days past due, they're automatically off. The board doesn't need to approve it. If they're more than 90 days past due, they're automatically off. The fourth one, which we just talked about, is criminal charges, okay, involving certain crimes. And you can go back a slide or two and see that list there, okay? The fifth one is the state of Florida via the Division of Florida Condominiums. They can order a director off. So that's the fifth way. Way 6 is if you don't get certified to be a board member. Now, that's temporary, right? So you all are taking the board certification course right now. So I think that's wonderful. But if a board member fails to do it, they're temporarily suspended. Okay. And then once they satisfy that, they're immediately brought back on. Now, let me get some water. Regarding meetings of the board, the law was recently changed. In 718 right now, they actually require expressly boards to meet at least once each quarter. Okay. So 4 times a year, a board must meet. And at least 4 times a year, so it could be at that quarterly meeting, the agenda must include an opportunity for members to ask questions basically about anything they want. Now, that doesn't mean the board has to have a substantive answer ready to go. It just means that you have to allow the opportunity for owners to speak on any association operational matter that needs to happen 4 times a year. Okay. We get asked sometimes about ratification. That's just a fancy word. It means approving something after the fact. Certainly, we don't advise that to be, a regular course of action, but sometimes extenuating facts requires the board to take action outside of a properly noticed board meeting. If that does occur, certainly we advise to ratify it at the next board meeting, and the minutes of the board meeting should reflect that a majority of the board ratified that action. Regarding board members emailing each other, the law clearly states you can email. That's okay. You just can't obviously formally vote on an item via email, right? Because formal decisions of the board should happen where? They should happen at duly noticed board meetings. Now, the notice requirement, hopefully you all know this, but except for a couple items that I'll talk about, notice of board meetings with an agenda must be posted 48 hours in advance. Okay, so 48 hours is the rule of thumb. The couple exceptions where you need to mail and post board meeting notice 14 days prior is where the board will be considering adopting a special assessment. And that agenda item for the special assessment must state what the approximate cost of the special assessment will be and what the reasons for the special assessment are. Okay, and that must be mailed and posted 14 days prior. Also, another board meeting that requires 14 days notice to be mailed and posted is if the board is considering rules regarding the use of the individual units that must be mailed and posted 14 days prior. Okay. Similar to meetings of the owners, this is a very similar slide, but if you're required to have a website, right now, if you have 150 or more units, you have to have one. And again, beginning January 1 of 2026, if you have 25 or more units, you have to have a website. But if you have to have a website, all board meeting notices must be posted on the website. Okay. Now, regarding, obviously, notices must have agenda items. If an item is not on the agenda, the board is not supposed to be voting on some non-agenda item. Okay. Now, the statute does say an item not on the agenda can be taken up on an emergency basis if you have a majority +1 of board members agree to do that. And then obviously such emergency action is then ratified at the next board meeting. But if it's not on the board meeting agenda, the board is not supposed to be formally voting on any non-agenda item. We get asked a lot, owners may want the board to put something on their agenda, and the statute has a process where 20% of the owners can request that the board add an item to the agenda. And then there's a time frame where the board has to have a board meeting and put that item on the agenda. It's kind of a quirk. The statute doesn't require the board to vote on that item that the owners requested be put on the agenda. It just needs to be on the agenda. Okay. Again, that's if 20% of the owners request. That's how the owners can force an agenda item. As far as owners participating in board meetings, very similar to the ability of owners to participate in meetings of the owners, right? Meaning owners get to attend board meetings, they get to speak. We talked about how the agenda item at least 4 times a year must allow owners to ask questions basically about any condominium matter they want. So there is no method under the law for board members to silence owners or to prohibit them from attending and speaking. There are a couple items under the statute which allows the board to have a closed board meeting where owners do not get to attend at all. That's right on the top of this slide. That's where the board is meeting with the association's attorney to discuss proposed or pending litigation matters or where they're getting legal advice from their attorney, that board meeting can be kept private. Okay. Now, you're still supposed to post notice 48 hours prior, and it should say close board meeting with the association attorney. So that's one exception where a board meeting can be closed when the attorney is there dealing with legal matters. The second item where board meetings can be closed is when you're discussing personnel matters. What does that mean? That means when you're discussing, let's say you have an association employee and the board's thinking about perhaps firing them. Okay, that board vote, when you're chatting about it, about personnel matters, that can be a closed board meeting. Again, you're still supposed to technically post the notice of the closed board meeting 48 hours prior. You could just say closed board meeting to discuss personnel matters. Okay. Just like meetings of the owners, owners can also record meetings of the board as well, subject to these reasonable rules there. Again, we just highlight that owners get to participate in meetings of the board, and they get to ask questions at least 4 times a year about basically anything. The reason why I say that is you can see from this slide, the right to ask questions. It can be about reports or the status of construction or repair projects, the status of revenues and expenditures, and other issues affecting the condominium. That other issues affecting the condominium, that's what lawyers call a catch-all, right? So it could be anything. So again, owners have the right to speak on those items. Now, this last point on this slide, the board can adopt rules about how long owners can speak. You know, we hear a rule of thumb, 3 minutes seems to be a reasonable amount of time. And certainly when owners can, you know, chat, but you can't silence them. But you can certainly say this is the point of the owners meeting where we'll allow owners to speak. Just like meetings of the owners, a meeting of the board will only happen if you have a quorum of the board members who are there. Quorum is just a majority of the board, right? 50% plus 1 of the board. Now, a board member can attend a board meeting via speakerphone. If you have a board meeting via like Zoom, the board member can appear and establish quorum at that board meeting via speakerphone or Zoom or any other sort of conference software that there is out there. Votes of the board at a board meeting, they are not secret votes. A board member has to cast their vote out loud. The only time a board member can vote via like a written ballot is when the board is holding its organizational meeting of the board, where they vote to appoint who the officers will be. That's the only time a board member can vote in any other fashion besides out loud. Okay. For board meetings, there's no proxy voting. If a director can't show up, they can't give their proxy to some other person to vote in their role as a member of your board. Committee meetings. We talked about the grievance / fining committee. There could be other types of committees that are established as well. The committee meetings are subject to the notice requirements, and owners get to appear, okay, just like a board meeting. The only time committee meetings are exempt from the notice requirements is if the bylaw specifically exempt them, okay? So just be aware of that. If you do have formal committees established, they're supposed to have notice posted and allow owners to show up. All right. A couple more sort of important topics, and then I'll definitely save some time for questions. Insurance, obviously, this is a pretty huge operational aspect, and board members need to be made aware of the insurance requirements. Talking about property insurance. Some people call it casualty insurance, but obviously the association is required to have insurance to protect the physical condo property. Okay. The amount of insurance should be based on what the replacement cost is of the condominium property. And that replacement cost must be determined by an insurance appraisal once every 36 months. Okay. So that's property insurance. The way the statute reads is the association insures everything except for, and let me jump around here. The association must insure all the condo property except for these items on this slide here, which is the unit owner obligation to insure. So in the slide where you see in the second bullet point, the association's coverage must exclude, and it has a laundry list of things. Those are all interior unit items, personal property, coverings of the floor, wall, and ceilings, appliances, water heaters, all of that interior unit, those items, that's the insurance obligation of the owner. Okay, that's excluded from the association's property insurance. So basically, the association insures everything but the list of things here. Why this is important is the insurance obligations of the association and the owners, they come into play when there's damage from an insurable casualty event. What does that mean? It means some sudden unforeseen event, a hurricane, a fire, a water heater burst out of the blue. It's not dealing with general wear and tear or something. There's a slow maintenance problem, okay? If there's a slow general maintenance problem, the governing documents of your community will set forth who's responsible to fix what. I'm only talking about when the damage is from an insurable casualty event, hurricane, fire, some other sudden unforeseen thing. If there's damage from a sudden unforeseen event, the analysis is quite simple. The party who's responsible to fix the damage is the party who insures it. So if the damage from an insurable casualty event is to one of these items on this slide here, that's the owner's insurance obligation, and the owner is required to repair that. Alternatively, if the damage item is an item that the association is required to insure, something that's not on this list right here, then the association is the party who insures that, okay? And that's what this slide goes into, repairs after a casualty. Now, the exception is where the association would not be responsible to repair an item that was damaged that they're required to insure, is if the source of the damage is the negligence or improper action of an owner. Okay, a common fact pattern that happened is I wouldn't say a common fact pattern, but a fact pattern that happened to one of our clients is a unit owner thought it would be a good idea to hang his clothes, about 30 hangers full of clothes, on the sprinkler inside of his condo. You could see what happened. The weight of the hangers burst the sprinkler. A huge water leak went down multiple floors. So we had an insurable casualty event, right? The sprinkler, being broken by that hanger, that's a sudden unforeseen thing, right? That's not general maintenance. So we had a sudden unforeseen insurable casualty event. Now, there was damage to the common element property that the association is required to insure, right? Because it went through multiple floors. Usually, the association pays for damage to the property that it insures. However, since the source of that common element damage was the negligence or improper conduct of that owner, the association is able to seek recourse directly from that owner, okay? All right, let me go back a couple slides because I was dealing with property insurance, okay? I want to talk about a couple other types of insurance that an association must have, which is fidelity bond insurance, okay? This is insurance that covers anyone who has control of the association money, the funds of the association. So you must, and this is a statutory requirement, must have fidelity bond insurance to cover the maximum funds that are in control of the condominium at any one time. So if you're not sure if you all have the proper bond insurance, definitely get with your insurance agent to walk you through that. Okay, so that's fidelity bond insurance. Also, I wanted to mention, while it's not on this slide here because it's not required, we certainly recommend that the association obtains directors and officers liability, often called D&O coverage. D&O coverage deals with claims of mismanagement by the board. Willing to bet that all of you have D&O coverage, but if you have any question at all, definitely get with your insurance agent. Really, your agent should be walking you through all your policies that you all have, okay? And answering any questions you all have, as well as pointing out any exclusions that might be in your insurance policies and chatting with you if there's any riders that could possibly be obtained to sort of close any gaps or any exclusions in your insurance policy. All right. All right. Last topic of the day. And then again, we'll save some time for questions. I'm talking about conflicts of interest, which in my experience is a pretty misunderstood concept. We have lots of sometimes owners or board members that they think lots of things are conflicts and therefore on the face illegal or on the face in violation of the Florida statutes. And hopefully by the end of going over these slides, I can sort of clear up what actually a conflict of interest means when we're talking about a condominium association. What we're talking about is it's when the association itself enters into an agreement with a member of your board or an officer or a company that's owned by a director or an officer or a family member of a director or an officer. But the main point is it's the association is entering into a contract with a board member or an officer or a family member of a board member or an officer. If that happens, that is deemed a conflict of interest. However, it does not mean that it's on the face prohibited. And that might be a surprise to some of you. But what the statute says, and I'll kind of walk you through this here, if the association is entering into that type of contract, there's certain disclosure requirements, which, if done properly, allows that contract to go forward, okay? The main one is the conflict must be disclosed at a meeting of the board, right? John Smith has to say, I'm John Smith. I'm on the board. I'm a treasurer. I own John's landscaping company that the board is considering hiring. That disclosure of that interest happens at a board meeting, and the minutes of the board meeting must show that disclosure was made. Also, that proposed contract with John's landscape company, that must be attached to the notice and agenda of the board meeting so owners can see it, okay? That contract needs to be approved by 2/3 of the board members, okay? It's not just a regular majority board approval, okay? So it's very important that you realize you do need that super majority vote of the board. Also, the contract with John's landscape company certainly needs to be fair and reasonable. And the subject director, during the portion of the meeting when the other board members are talking about his contract, he needs to leave the meeting. He can't be there, and he obviously abstains from voting. Okay. So there's several disclosure requirements, but it's important to note, if the disclosure requirements are done, it's fair and reasonable, you get that super majority approval of the board, the association can enter into a contract with John's landscaping company, even though that's owned by John, who's on the board. Now, I'm not suggesting it's a practically great idea to do that. I leave that to the reasonable business judgment of the board. Okay. But it's improper to state that it's always on the face of violation of the statute to do that. That's not the case. We've had certain clients where a member of the board or a member of the immediate family of that board member, they had a very specialized engineering firm that did certain specific jobs, and they were the best in the area for that type of engineering work. And their bid came in very reasonable and fair. There's a strong argument, why should that association be prohibited from doing what the board thinks is the best interest of the entire community by hiring the best engineer that's available for that type of specific specialized work, as long as all the disclosure requirements are met, as long as the terms are fair and reasonable, and as long as you get 2/3 approval. Okay. Now, let's say that's all done. All of the required disclosures are made. What the statute says is, at the next meeting of the owners, an owner can make a motion to cancel that contract if a majority of the owners who are there approve canceling that. I can share with you, I've never seen this type of owner cancellation happen. I'm not saying it couldn't happen. I'm just saying I haven't seen it happen. What's interesting is what if the contract was only for a short period of time? It was that engineering contract I'm talking about, and the engineer services finished in 3 months, and the next owners meeting wasn't until 9 months later. At that point, practically, there's nothing to really cancel by the owners because the services and scope were already done. But I just want to make sure I pointed that out to you as well. All right. Just wanted to point out, I'm really not going to spend a lot of time on this, but the similar conflict of interest requirements for a contract that the association is hiring with a company, you know, that is owned by a board member or an officer or a family member. The same type of disclosures and conflict of interest is for the management company as well. And there's certain disclosure requirements that a licensed community association manager or a community association management firm must do. And we walk you through these on these 3 slides. And obviously, you should be aware of that. I'm going to venture to guess that your management company contract, if they have some ownership or some business relationship with other companies, I'm venturing to guess it's in their management contract that you all have. All right, with that being said,